Justices of the Appellate Division, Fulton, Harper, hear ye, hear ye, hear ye. All persons having business before this court will draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. First case for argument on the calendar today is People versus Sando 652, and also we'll call 657 with it. Both counsel are remote. Ms. Myers, good morning. We're waiting for Mr. Sando.
Good morning, Your Honor.
Is Mr. Sando checked in?
Judge, he isn't. He just has not started his video yet.
We'll give him a
He
moment.
can't hear you.
Tell you what, why don't we call 653 People versus Detroit Kelly while we wait. We'll come back to you, Ms. Myers, momentarily. 653 Kelly is also, we have, you're here, okay, you may proceed.
Good morning, Your Honors. Jane Yoon for Detroit Kelly. Unless the court has questions on point 1, I would like to focus on point 2. Okay. The executive orders that are at issue here in this case are unconstitutional because they do not comport with the authorizing statute. Specifically, Executive Law 29A governs when, or the requirements when the governor decides to suspend the statute. So we're not contesting the governor's ability to suspend any statute or ordinance or that sort of thing, but we are contesting whether or not the governor was within his bounds. And so Executive 29A...
Here you saw a question coming, Ms.
I did.
Very well, very good. Here the issue is the people pointing out is that tobacco case. Again, assuming we get beyond issue 1, that I
Right.
understand you're not addressing with the waiver.
I'm happy to answer any questions about it.
No, that's fine. But tobacco is the case. I'm probably mispronouncing, but you know what the case I'm referring to.
Yes.
So we've got to take a close look at that to see if we're going to get in line with that, I suppose, would be, and you would say we shouldn't because the plain language of, I think it's the first executive order, or maybe it's the second, is inconsistent with that case. So am I generally on the right point that you want to address?
Yes, Your Honor. So I think with the tobacco case is really looking at a semantic argument there. Does the necessity requirement qualify suspending or tolling, right? And I think in our case it doesn't matter quite as much because our position is that even if you're suspending, and I think the tobacco court came out and other courts in the Second Department have also kind of followed that line. There's another Second Department case. It came out in March of this year, I believe, so it's not briefed in my cases, but it has the same reasoning as tobacco, talking about does that phrase, the necessity phrase, apply to the suspension or the tolling. But here, the argument is really that what the tobacco court missed, and it may be that counsel just didn't raise it in the tobacco court, was that the tobacco court didn't look at the statute within the confines of Executive Law 29A, which says that there still needs to be, when you're suspending a statute, it has to be the minimum deviation requirement. So they kind of just either ignored it or didn't look at it because maybe counsel didn't raise it. I couldn't tell from the briefs that it was raised there. So we're asking for an overarching, a higher review of the statute because the statute is governed and authorized by Executive Law 29A.
Not that we couldn't do it, but you would agree that we would be the first court in the state of New York to follow that argument, right? So we'd be breaking new ground, to say the least.
You would be breaking new ground in the appellate division courts. There have been some lower level courts downstate that have agreed with that, not necessarily in terms of the grand jury aspect of it. The Zioli case talks about the application on the ACDs. So, but yes, and there's always a first for everybody. I encourage you to be the first.
We will look carefully at that argument. Anything further?
Thank you, Your Honor.
Good morning, Your Honors. Ryan Ash for the People. Regarding the minimum deviation argument.
Mr.
Yes,
Ash,
Justice.
the appellant has, relied on the briefs with respect to issue 1, but in your brief, you talk about the waiver of appeal, you talk about preservation. We've got to look at those issues as well.
That's my argument too.
Right. But if we get to the merits is where you are now. I don't mean to cut you off. I'm
Right.
trying to
Just
structure it for the panel.
Yeah, and my brief's kind of goal was to take the word constitution, and there's constitutional speedy trial arguments, yes, but there's also the Constitution, the New York Constitution is involved too, and those are separate issues, even though they both have the word
So
constitution in
your
them.
view is the waiver encompassed the speedy trial claim, but not his constitutional speedy trial issue.
Yes, the statutory, anything doing with the abrogation of CPL, that's a statute, and even though it's raised in the constitutional powers of the governor, that's a statutory claim, which is covered by the waiver of appeal.
Are you aware of these trial court decisions that counsel was talking about that went her way on this issue?
Yeah, and those were analyzed, I believe, in the one trial court decision, Aiken, which was actually adopted, the rationale at least was adopted by the Tabbett court. And that's why I would urge this court to not be the first to go along the counter reasoning, is that I believe it was the Second Department, they analyzed all the rationales and decided that this one is the more credible argument. And regarding counsel's argument about minimum deviation, here, not every aspect of CPL 3030 was delayed or suspended by these executive orders. So in that way, it's not as if the executive orders came down and suspended all rights to all defendants in every situation. This is specifically a case about pre-arraignment delay. And if the court doesn't have any other questions, I'll rest on my briefs.
Thank you.
Thank you.
We're going to return to 652 and 657. Mr. Sando is with us now. And we will wait now for Ms. Myers to rejoin us. Good morning, Mr. Mr. Sando, you may start your argument, please.
Good morning, may it please the court. Thank you for taking the two appeals together, Your Honor, and I apologize for my video problems.
No problem.
652 involves a conviction for sexual abuse in the third degree and for touching. We submit that there was no waiver of appeal in regard to this conviction. The court only talked about a waiver after the defendant pled guilty. It wasn't a condition of the plea, and there was no written waiver. And insofar as the guilty plea is concerned, there was no recitation by the trial court of any facts as to this prosecution. But just how do you plead to this crime and that crime? And there was no explanation of the rights that were given up. Insofar as 657, that includes disseminating indecent material to a first sexual performance by a child, or the defendant prosecuted by SCI. We submit also that the waiver of appeal was not mentioned until after the guilty plea, and the pricing or procedure that this court laid out years ago not followed. The waiver was not a condition of the guilty plea, and the waiver itself was on page 42 of the record, or otherwise absolute bar we submit is overbroad. And insofar as the guilty plea is concerned, there was no complete inquiry by the trial court as to what rights the defendant was waiving, and apparently the court relied on the defendant's conversations with his attorney, but those were never set forth to the trial court. Insofar as the sentence is concerned, I realize that the 10-year probation is necessary. We would ask that there just be one 10-year term of probation and not two. And otherwise, we'll rely on our brief unless the court has any questions. And thank you, Your Honor.
Thank you, Mr. Sando. Ms. Myers?
Thank you, Your Honor, and may it please the court. Initially, I would like to apologize. I did not point this out earlier. It's not Morgan Myers, it's Morgan Mayer. So I would like to note that for the record.
Okay, my apologies.
No, thank you, Your Honor. And in this case, I think the overarching issue in both appeals is the sufficiency of the colloquy for both the plea and the accepting of the waiver of appeal. And I would first like to note that there's no set colloquy for either of those. And therefore, it's obviously our position that they were both adequate in both cases. And when viewed in the totality of the circumstances, the waiver of appeal is valid. It was taken separately from the plea, which is required to be separate and distinct from the plea of guilty, based on case law from multiple courts. The waiver outlined that the defendant was waiving rights taken to challenge errors that may have occurred, and the court did confirm that there was a signed waiver. Now, I acknowledge in case number 01311, the record does not have a written waiver of appeal. I think it's unclear because the court did discuss a writing when discussing all four convictions or all four pleas taken. So I think that's a little unclear on the record. There was a written waiver given for the felony case. So we would just ask the court to note that. And we do continue with our assertion that the issue of the plea of guilty is not waived. In either cases, the defendant made no attempt to withdraw his plea at any point. There was no indication that he did not understand the plea. There's nothing to indicate that he didn't understand that he was knowingly, voluntarily, and willfully entering the plea of guilty, and therefore the issue is not preserved for appeal. And lastly, I would just like to touch upon sentencing. There is some discussion of the defendant accepting responsibility. I would like to note that there's a lot of deflecting in this case. I apologize.
Well, counsel, the defendant, he got probation.
Yes.
He got local jail. He served that. So it's just probation now. He has
Correct.
2 10-year terms of probation that are concurrent. Is that correct?
That's correct, Your Honor.
And can we even reduce 10 years probation? I think that's the minimum, is it not?
I believe that's the minimum, yes.
So,
That's my
all right.
understanding.
We understand your argument. Thank you.
Okay, thank you, Your Honor.
654 is People versus William Sullivan. 654. Mr. Schifrin, good morning.
Good morning, Your Honor. The police questioning of Mr. Sullivan consisted of a series of Miranda violations. First, Mr. Sullivan was subjected to custodial interrogation prior to being read his Miranda rights when Detective Reed repeatedly made statements and asked questions about Sullivan's wife, emotions, the nature of love, and the nature of the marital relationship. The detective's questions and statements were not merely likely to induce a response, which of course is the test for interrogation under Rhode Island versus Emeris, but given the fact that Mr. Sullivan was in custody on allegations that he had assaulted and kidnapped his wife, that was the very purpose of these questions.
Mr. Schifrin, that contention is not preserved, is it?
Oh,
The lawyer below did not make that argument. The lawyer below argued that the first no, sir, after Miranda warnings, that invoked the defendant's right to remain silent. And that's where the Fifth Amendment violation occurred. We understand your first argument is laid out in the brief. Could you move to the second one?
Let me please respond to that. On page 18 of the record, in the written motion at paragraph 4D, there's an express motion by the defendant to suppress the statements because they were questioning prior to being advised of Miranda. That is this issue. Second of all, at page 205 in the record, The court, in deciding to deny the motion, expressly addressed that portion of the motion by holding that in fact, prior to interviewing Mr. Sullivan, Miranda warnings were given. So respectfully, Your Honor, this issue was raised in the written motion and was decided by the court.
Would you agree that it was not raised in the defendant's post-hearing memorandum?
Absolutely. But given that it was in the motion and given the fact that the court addressed it under CPL 47005 subdivision 2, this issue was raised. There's no requirement that every issue raised in a pretrial motion also be addressed in the memorandum. In this case, it was raised in the pretrial motion and, most importantly, was addressed by the court in the decision expressly at page 205. So respectfully, it was preserved in the front end on the motion and was preserved by the court addressing it. I think it's important to note after that interrogation without Miranda, Mr. Sullivan gave a statement saying he was pushed on and he flipped out on his wife. Then without any break, Miranda warnings were given, continued questioning on that issue, and the more inculpatory statements about what he did to his wife. Under Bethea, both the elicited unwarned statements and the elicited warned statements all have to be suppressed since there was zero break with the same officer in the same location for questioning. With respect,
in any event, you have, even if that's unpreserved or it lacks merit, your argument is that, and this is a rare case, I haven't seen too many cases where the defendant, when he's asked after Miranda, he says he understands his rights and so forth, and the officer, the detective says, do you want to understand all his rights? Do you want to talk to me about this? He says, no, sir. Your position is that's unequivocal. He invoked his right to remain silent. Nothing's more unequivocal than no. And the officer, the detective can't then try to talk him out of it.
That's correct, Your Honor. No means no. There's nothing ambiguous about it. The only time you need interpretation is when there's something that's ambiguous. There's nothing more clear as to how you can say the word no than saying the word no. There's three ways you can respond to that question by the officer. Yes, maybe it depends, or no. Mr. Sullivan answered no. At that point, under this court's holding in Prefer versus Morera, which both Your Honor, Justice Lindley and Justice Curran were on the panel, when a person subject to police interrogation indicates in any manner that he wishes to remain silent, the interrogation must cease. It wasn't. Instead of scrupulously honoring this unequivocal assertion of the right to remain silent, what the officer then did was engage in a series of statements and questions with the purpose and goal to getting Mr. Sullivan to waive the very right to remain silent, which he had just invoked. As the Supreme Court held in Smith versus Illinois, the fact that was successful is irrelevant because it was improper questioning. The police can't benefit from their violation of Miranda, and that's exactly what they did. He was advised of his right to remain silent. He invoked his right to remain silent, and the officer ignored that, kept on asking questions until he got the statement. That is improper, and everything that flowed from there had to be suppressed.
Would you agree? I'm sorry. Go ahead.
First, please.
Would you agree that a defendant who invokes the right to remain silent, as opposed to the right to counsel, can change his or her mind, as long as it's not prompted by the police, it's not coerced or induced? But this defendant could have said, "Yeah, I don't want to talk to you." Then the police officer, the detective, starts packing up his stuff, and the defendant says, "You know something? Actually, I will. I changed my mind." That would be fine, right?
Absolutely. Very different circumstance here. There's also cases where there's a gap in time. After a period of time, the defendant again indicates a change of mind. That did not happen here. The immediate response by Detective Reed to the answer "no, sir" was to engage in a series of questions designed to attain the waiver of the right which had just been invoked. That is the very thing that Miranda prohibits. To permit that was effectively to overrule Miranda, because Miranda says you have a right to remain silent and you have a right to, and you can invoke it. And he invoked it. What more can we ask of the defendant saying no?
I'm sorry, I should have let you finish your thought.
My apologies, Your Honor.
You did a nice job in your brief of laying out the timing of the no, sir. And then what the next thing that the officer does is seems to almost as though he didn't this is my take, and I don't think it's exactly accurate. Almost like he didn't hear the defendant. "No, sir, you won't answer any of the questions." Are you saying that the fact that the officer then said, "No, sir, you won't answer any of my questions," that was right then and there? It tees up the violation of Miranda.
Yeah, yes, yes,
That's
Your
the
Honor,
moment.
because the word no, sir, at that point, all questioning must cease. The no, sir, what do you mean by that? The Supreme Court held in, pardon me.
And
in
Mr. Schiffer,
American
just so you know,
versus
I
Barrett,
think.
you can only ask follow-up
Mr. Schiffer,
questions.
time out. Mr. Schiffer, just time out. And I'm sorry to do this to you, but I am trying to pin you down on the time where you say the violation occurred. And I promise you I'll let you continue, but this is what's troubling to me is that is your argument that the no, sir, you won't answer any of the questions. That was the impropriety that you say violated Miranda. That may well be the law. As you point out, I was on Marrero, and I'll take another look at that. So thank you for listening to me. That's really what I'm focusing on is the time frame, because just to point it out and give you a chance to respond, the law is that we're to defer to the court's credibility and determinations here. And for us to agree with you, we would have to find that the court's decision at page 207 on the record was unsupported by the record. But the court seems to think that when the officer said, "No, sir, you won't answer any questions," that's when the defendant opened the door to continuing talking. That's what I'm troubled by. And thank you for listening to me. I'd love to hear your response.
As the Supreme Court held in Connecticut versus Barrett, cited in my brief, the only time it's permissible to ask questions to clarify the response of the invocation is if it's ambiguous. So if Mr. Sullivan said, no, because I'm not sure what you're asking about, no, but that wasn't what was done here. Again, there's three ways you can answer: yes, maybe, or depends, or no. He said no. At that point, further questioning was improper. That question, Your Honor, and I'm answering your question as directly as possible, was an improper question. He didn't simply say no, no, sir, again. He said, "Oh, are you saying that you're not going to answer any questions?" That's what he said. That's what no, sir means. What else could no, sir mean when we ask the express question, are you willing to answer any questions? And he says, "No, sir." Says it politely, but it was
Well,
not
Mr. Schifrin,
it was the word no.
Mr. Schifrin, there were, I'm just curious about something. That wasn't the last no, sir. There were at least three more no, sirs in response to questions from the detective. Do you want to talk about it? These all came before the statements that were noticed in the People 71030 notice. These all came before those incriminating statements. So even if that first one didn't invoke his right to remain silent, there were three more to follow. But you don't make that argument. Again, there were four no's before the incriminating statement. This guy the detective blew through four stop signs. You're relying just on the first stop sign and you're not arguing, are you? I didn't see it in your brief and I didn't see it argued below that. Well, even if he had justification for going through the first stop sign, the detective didn't have justification for going through the second, third, and fourth. That argument isn't being made?
We argue in our brief that there is a duty to scrupulously honor the invocation of the right to remain silent. That was violated by the repeated questioning. Each question was a violation. Each question, our argument is that all questioning needed to cease. So every question was asked after the initial no, sir, was improper. All responses cannot be considered. Again, I cite Smith versus Illinois, because they're all the product of the violation of the invocation of the right to remain silent. So in answer to your question, I might not have expressly said each no, sir, but I did argue in the brief, but we did argue in our brief, and it was argued in the motion below. Actually, the court in its decision acknowledged the scrupulously honor standard, and they said it was met. Our position, it wasn't met, because if you scrupulously honor the invocation of the right to remain silent, you stop talking. You might ask him, you want to go, you need a Coke. You can't ask him questions.
We understand.
About interrogation.
Your time's running low. Could we move to your second argument with respect to the statements in the holding cell?
In the holding cell, this is after he again invoked his right to remain silent. Detective Reed leaves. He's in the holding cell. Detective Reed comes back from 100 Sheridan Place, where he observed a large quantity of drugs. And Mr. Sullivan says to him, "I know we have more drugs coming in." That statement was the product of interrogation, because the only way that Mr. Sullivan could have known that Reed had gone not to his home, that 100 Sheridan is not Mr. Sullivan's home, there was another property associated with the Sheridan, and has gone inside and seen those drugs, is because that's Detective Reed had told him that. Therefore, under Farrow and Innes, that telling a suspect that, hey, by the way, I went to Sheridan Place, there's a lot of drugs there, that is the functional equivalent of interrogation, because the purpose of that is to provoke a response, which is what it did. And one quick final thing.
To follow up on Justice Curran's point with the first issue, you're asking us to make different factual determinations than the hearing court. The hearing court found it was spontaneous. You're suggesting, and I think you make a lot of good arguments. It doesn't make sense that this guy would just volunteer out of nowhere to help out on drug charges. Given these facts, it would seem like he would have had to been told, hey, we searched not only your house, but your stash house is what we found. But to do that, we have to say the trial court's factual determinations, we'd have to make our own fact finding here, would we not?
You would, because there's no record support for the possibility of Mr. Sullivan knowing that they've been in Sheridan Place and seen the drugs, other than having been told that. It is logically impossible, and therefore the fact finding is not worthy of affirmance. And one quick final thing before I rest. Harmless error is inapplicable here. The day after the erroneous denial of the suppression motion, Mr. Sullivan entered a guilty plea. In addition to the drug charge for which he faced 20 years, not mentioned in the respondent's brief, he faced 25 years on a kidnapping 1 charge. Most of the statements that he made in the unlawful interrogation went to that charge. He made all sorts of admissions, okay? It was only after that was denied, because he was facing that kidnapping 1 carries with it 25 years in it, consecutive to the drug charge. So he was facing 45 years. As soon as it was determined all those statements were going to be admitted and he's going to lose the kidnapping charge, he takes a plea to 18 years on the drug charge, which is only 2 years less than the maximum he faced. There's no reason to have taken that plea if the suppression motion had been granted. For all these reasons, we urge reversal of this conviction. Thank you, Your Honors.
Thank you.
Morning, Your Honor. David Bassett for the people. Turning to the pre-Miranda statements, our position is that this issue was not preserved.
Was it addressed in the motion and then in the court's decision?
I believe it was addressed in passing in the court's decision.
Well, doesn't that preserve it then?
Well, even if we were to get to the merits of that issue, our position is that the detectives' comments and were not reasonably likely to elicit an incriminating response under Rhode Island v. Ennis, and in fact did not elicit an incriminating response. I'm not sure what defendant is referencing as far as incriminating statements that were made before the Miranda.
Well, the flipping comment that he flipped and they were fighting. And look, I mean, when I watched, all of us, by the way, watch that video very carefully, numerous times. And was a bit surprising. He started to get into the allegations from the wife, which is the reason he was down there, the main reason. And before he does Miranda, before the detective advises the defendant Miranda, he's discussing the crime for which the defendant's in custody. Does that surprise you the way it surprised me?
Perhaps a little bit, but I don't think he got into the specific allegations. He's talking very generally about relationship and love. And I would argue he just struck a responsive chord, as in Rhode Island v. Ennis, when the defendant responded, well, you know, that's why I was pushed the way I did. That's why I flipped the way I did. And flipping, I mean, that's not necessarily incriminating itself. It's not clear there was any incriminating statements made, or that Detective Reed should have reasonably known that his comments would elicit those statements.
And that wasn't in your 71030 in any event. 71030 was limited to the duct tape and the box.
Right.
It occurred after Miranda. So you could have conceivably been precluded from introducing the pre-Miranda statements at trial by virtue of there not being in the 71030. So if that had been argued, you know, precisely perhaps is the word, the court could have addressed that, but you might have well been bound not to even get into the pre-Miranda based on your 71030, correct?
Right. We weren't looking to use those pre-Miranda statements as the
Right,
court.
but this is the problem. If the pre-Miranda statements led to the post-Miranda statements, then there's a Fifth Amendment problem. That's what Mr. Schifrin's. I don't think Mr. Schifrin's too worried about what the defendant said pre-Miranda. He's arguing that the violation there led to the incriminating statements, and that's why he wants the incriminating ones suppressed.
I understand that. And our position is that there was no custodial interrogation pre-Miranda. Miranda was not required at that point. And then Detective Reed properly administered the Miranda warnings approximately 90 seconds into this
Right.
fairly innocuous conversation.
How about the
With-
no? Go ahead.
Just with respect to the proper Miranda warnings, when we watched the video, the one thing that became apparent is that Detective Reed elicited these responses, and he gets to number 7 on the sheet. He's writing them down as he's going. Detective Reed's writing it down.
Mhm.
As the defendant is responding, he gets to number 7, he writes down, "No, sir." He says, "No, sir." He writes down, "No, sir." And then they begin this 53-second discussion back and forth, which ultimately leads to him saying, "All right, well, let me hear what you have to say." Detective Reed convinces him to let me hear what questions you have to say, which didn't happen anyway down the road. But prior to that, prior to the defendant saying, "All right, I'll listen to what you want to say," Detective Reed had taken the clipboard and tossed it out the door onto the floor and closed the door. So this statement on the 7/10/30, "I will hear," that must have been added after the defendant signed it. Did you notice
My
that?
understanding is that
You want to take another look at it?
he initially wrote, "No, sir." And then there was the brief exchange about "No, sir," meaning you don't want to answer my questions.
Well, hang on. After he wrote "No, sir," Detective Reed handed him the clipboard and he signed it and dated it and timed it. Handed it back to Reed. Reed throws the clipboard out in the hallway. At this point, the statement "I will hear," that's not on the page, and that's after he signed it. This appears to be new to you.
I guess my
you didn't see it
recollection
that
of the
way.
video is a little different, Your Honor.
All right.
Trust me, Justice Nowak is right. We've looked at that every
Okay.
which way.
Well,
No, it does, I'm not necessarily saying, I guess his question may be, because I interrupted here, is whether that makes a difference. Like you would say, a lot of times you don't need, a defendant can just orally waive Miranda. You don't necessarily have to, but what's the significance of this later, "I will hear" added in clearly after the defendant's already made a statement?
I think to the extent it was added later, Detective Reed was memorializing what defendant said in the interview. Defendant says, "Yeah, I'll listen to your questions." Going back to the initial "no," you have to look at the context. Detective Reed follows that up, not with a substantive question, just with a clarification. He says, "No, sir, you're not willing to answer my questions." Defendant easily could have said no.
But why do you need to clarify a no? Like what
Well,
was ambiguous about, you would agree there's nothing at all ambiguous about "No, sir," right? So you agree with that?
Correct.
He's not hemming and hawing, well, so why the need? Mr. Schifrin's argument is there's no need for clarification questions here. And that's where the detective went wrong.
It appears that he may have either not heard him, or it's possible that he's going through a list of questions and he wants to be doubly sure that defendant said "No, sir," with regard to this specific question. And so he asks a simple clarification and defendant starts wavering, equivocating. And then Detective Reed says, "Oh, let me explain it to you again. You don't have to answer my questions. You can listen to them and you don't have to answer anything." Defendant says, "Okay, perfect. I like the way you explained it. I'll listen to your questions." Then the interview proceeds from there. This is our position, is an equivocal invocation. It's not clear and unambiguous as this court requires. Therefore, the statements that followed it were not in violation of Miranda.
How about the subsequent "No, sirs" before the notice statements? What was ambiguous about that? I mean, he made it clear 4 times. And then what was most telling is that the detective says what is obvious. He says, "Look, I know you don't want to talk to me." He says, "It's obvious you don't want to talk to me." And the guy says, "Yeah, I know." And what happens? The detective keeps going. And then the incriminating statements come. Are you suggesting that it was proper for the detective to ignore all those no's and just keep going with his interrogation?
First, I would say the only no objected to below was the first no.
Correct.
The following no's arguably are not preserved.
Not even being raised on appeal.
Right.
Okay.
And so You don't need to get into them necessarily, but I did not count 3 or 4, but there appeared to be additional resistance. And I will say that resistance was not enough to clearly communicate a desire to cease questioning indefinitely, as this court requires. There was a free-flowing conversation. You have to look at the words and the context, the demeanor and the tone of this conversation. Defendant is readily engaging back and forth with Detective Reed. And overall, looking at all the circumstances, and again, deferring to the lower court's finding of the facts, our position is that you should not disturb the lower court's ruling that there was no Miranda violation.
Except that, sorry. No, thank you. Except that following up on something that the Justice Presiding asked earlier, when we shift now to the next one, to the cell block, whatever it is, statement, there, of course, there were findings of fact that it was, equivocal, whatever the finding of the court was. But the Detective Reed, said what he was doing then was getting pedigree information. That, Mr. Bassett, that just doesn't ring true to me. He's got the date of birth on the Miranda statement. He knows who the person is. He knows where he lives. He knows where his stash house is, allegedly. So, the idea that the officer is going in there and is having pedigree information at that time just doesn't ring true to me. How do you answer that?
I would agree that he had some information already. Unfortunately, this interview in the holding cell is not recorded. The hearing didn't get into all the details of what he said.
Right, and whose burden is it at the hearing, though? That's the problem, is that we have very sketchy testimony about what was said and when in the holding cell. And if it were the defendant's burden, then maybe he didn't carry it, but I think it's your burden.
Well, I think we met our burden, Your Honor. Detective Reed was asked, and he answered that who initiated this conversation? Defendant did. Therefore, this was not the...
Right, but the question is, how does he initiate a conversation about, I got a lot more drugs, something like that, there's a big shipment, I can help you if you let me out. Like, it doesn't make sense that he would initiate that statement unless he knew they had searched his stash house and found the drugs. So obviously, he was told that. And what the answer is, well, they knew they were going to search his house. The drugs were found not at his residence, at this other house that he rented. And what's your explanation for how he would know that they searched that property?
I think it's logical for him to infer that based on circumstances. He has major drug trafficking paraphernalia that are in his residence, including a kilo press. His wife, who reported this domestic dispute, knew all about the stash house and told the police about it, that he frequently went there. It would be logical for a defendant to assume or infer that the police were going to find the stuff in the residence and then follow the trail to the stash house. A number of hours had passed. He knew that Detective Reed was seeking a warrant for his house, and he tried to help himself out. He said, I can get more. You think that's something? Wait till, let me out and I'll get the big fish. He's trying to help himself, and he volunteers this information. This was not solicited by Detective Reed.
Thank you very much.
One more question, just to clarify, going back to the original, the post-Miranda statement. Your argument is that there was this period of ambiguity from the time he said no, sir, until the time that he gave the incriminating statements, which was not 53 seconds later. 53 seconds later, he said, I'll listen to what you have to say. The incriminating statements didn't happen until several minutes later after the 4 no sirs. But you're saying that entire period was a period of ambiguity. That's your argument, right?
Right.
It's not your argument that he gave an unambiguous response, but then the defendant later changed his mind 3 or 4 minutes later and started volunteering. That's not your argument today, right?
That's correct, Your Honor.
All right.
Our position is ambiguous until 20 minutes in, he made it unambiguous and crystal clear, and he cut off questioning. Then the interview ended.
So there's no concern that if someone says no, sir, for an officer to go on questioning and talking to him and chatting him up for the next as really almost as long as he wants because we're still in a period of ambiguity.
I think if the answer to no, sir, if he says no, sir, and a law enforcement officer says no, sir, you don't want to answer questions, and that is answered, no, I don't want to answer questions, then it's over.
So he's
That
got to
didn't
do it.
happen here.
So your position is he has to do it twice.
Not necessarily, Your Honor. The no just has to be clear and unequivocal based on all the circumstances.
Fair enough. Thank you.
Thank you.
Okay, 655 is People versus William Fulton. 655. Miss Schwartz is remote. Good morning to you.
Good morning. May it please the court, Melissa Schwartz on behalf of Appellant William Fulton. Unless you have specific questions for me regarding any of my points, I'd like to do something unusual and start at sentencing and then briefly discuss point 2. Mr. Fulton in this case was a business owner, homeowner, had no prior criminal history, yet he received the maximum sentence for predatory sexual assault against a child. When I think about the maximum sentence for predatory sexual assault against a child, I think this person is the worst of the worst for this crime, right? Predatory sexual assault has a life sentence. It's a very unique crime for sex offenses because it makes them the equivalent of somebody who's committed a murder. So when a court is to impose sentence, they need to think, okay, he's already being penalized for the type of crime he's committed. So is there anything else we should consider in determining if he's the worst of the worst? In this case, I don't think Mr. Fulton is the person that qualified for that given his background. The people rely on the fact that he has a lack of remorse. I don't think that's true.
Ms. Schwartz, I know that the record includes that the daughter was hospitalized for suicidal ideation, and that is the problem here just that the daughter didn't carry through with her suicide? Is that why the sentence shouldn't be what it is?
No, Your Honor. And I think there's some debate on the suicidal threats that she made, whether they were legitimate, but that's already taken into consideration by the sentencing parameters for this type of charge. A defendant convicted is already being penalized for the impact of this type of crime. So the question is there anything else that doesn't make him the worst of the worst? How a victim responds to this type of crime certainly needs to be considered, but it's not the only thing that needs to be considered.
And your point is that what's your client's prior record look like? Is this first
zero
conviction?
prior criminal history.
Right. So your point is that if a guy who had done this 5, 6, 10 times, he's getting 25 to life. Your client, first time offender, is getting 25 to life. That doesn't seem right. Do we know what the pretrial offer was, either pre-indictment or pre-trial? Is that anywhere in the record?
It's nowhere in the record, Your Honor, and I did inquire on that with prior trial counsel. I don't believe there was one. Not that you guys can ultimately consider that, but I don't believe there was a pretrial offer based on my conversations with trial counsel. But also the people try to use what I think is a really common argument for these cases is that he has this utter lack of remorse. Take a look at his sentencing statement. He doesn't cast aspersions. He doesn't criticize her. I mean, we've all read a ton of sentencing transcripts where defendants take some ludicrous positions during their statements. He doesn't do that. You know, he makes a genuine, heartfelt commentary to his daughter. And if you believe that he committed this crime, of course, it doesn't get rid of the egregiousness. You don't get to say sorry, but you also don't warrant the maximum sentence. So I'm
right. These are types of cases where they're tough for the defense lawyers because it's a heinous crime. You would acknowledge.
Yes.
But I think your point would be, yes, it's a heinous crime. That's why he's getting a life sentence no matter what we do today.
Exactly.
The heinousness is built into the mandatory life sentence. Just a question of what's the first number going to be? 25, 20, 22, 70. So that the fact that it's heinous, of course it is. That's why he's convicted of this crime. You want us to look beyond that because that's already taken into consideration by the sentencing structure and look at some other factors like his prior record.
Correct, and I believe this court has to, right? There's parameters. Everyone convicted of this after trial can't get 25 to life. And it's in my experience that everyone that goes to trial on this is getting 25 to life by trial courts. I just want to briefly touch on point 2, which goes to the propriety of Investigator Russell's testimony. I'm not saying that he wasn't allowed to testify about the controlled calls made to my client where no admissions were made. He's allowed to testify properly to that. What I take issue with is him testifying about the safety plan. There's no relevance to that type of testimony. We had to create a safety plan just indicates to the jury that someone who's an expert believed my client to be dangerous. He also testified to the complainant's demeanor, right? Oh, she seemed okay until she started talking about the crimes and then she started to cry. There is no relevance to that besides to bolster her credibility to show that she was sincere when she was being interviewed. I don't think I would be making this argument if this case wasn't based on what I believe is just her testimony alone. I don't think the DNA evidence is compelling in light of his wife's testimony about the rug, the receipt that corroborated her testimony, and what are some issues regarding the complainant's credibility. This is
Ms. Schwartz, I'm sorry to interrupt. I just didn't want to lose the point, and you made it a minute ago. I know you're already kind of moving on to the next thing, but with respect to the demeanor of the victim, we have a case, People v. Ludwig, from 2013. Testimony regarding sexual abuse victim's demeanor is admissible to explain how the victim eventually disclosed the abuse and how the investigation started. Why is that inapplicable here? Assuming it's preserved, why is it applicable?
And I believe Ludwig is the disclosure to, I think it's a mom and a sibling or a cousin, right? And that's the initial disclosure. So in this case, it would be the complainant's disclosure to her mother. That would be Ludwig's complaint. This isn't the initial disclosure. This is her disclosing, and then the investigation into my client had already started. So I don't think it has the relevance, or it's not similar to the situation that's in Ludwig. And that's what makes it so egregious. And the proof, not overwhelming in this case. We have no admissions by my client during controlled calls, or no admissions during his interview. And then we have this really questionable DNA proof that isn't properly explained by the prosecutor or defense counsel. In her testimony, and I obviously hesitate to ever say a child's lying because it's an easy argument to make, but there are things in her history that suggest she has, questionable veracity, but which would be a lot easier for an attorney to make that argument if it was an adult. She had stolen from her siblings. She admitted that. She testified in grand jury about this lock, that turned out she corrects it. So I don't think this is the type of case that has this overwhelming proof that the conduct happened. And combination with Investigator Russell's testimony, I mentioned a few comments by the prosecutor. Her opening is about stuffed animals in the bedroom, and then her closing talks about, what did she have to gain by coming in here today? She had nothing to gain. And Investigator Russell also in a footnote testified, was asked by the prosecutor, did Mr. Fulton tell you why he thought she would make this up? Clear burden shifting. I think everything in combination, because it's preserved, that it requires reversal in this case, or in the very least, a modification in which I think is an unduly harsh sentence. Thank you.
Thank you, Ms. Schwartz.
Morning again, Your Honors. I'll just start with the evidence here. Jury found, and credible evidence showed, that defendant engaged in horrific sexual abuse of his own daughter when she was between the ages of 11 to 13 years old, including repeated rapes. The jury found that the minor victim was a credible witness. Defense asking you to find her incredible as a matter of law. As you know, it's a very high bar. There is nothing defense pointed out that shows any major inconsistency in the heart of her allegations. And we would submit, and the jury found, her testimony was corroborated by defendant's sperm found on a rug which had been in the minor victim's bedroom. Any issues defendants taking with the inconsistencies or biases of the minor victim go to the weight of her testimony, which was up to the jury to decide. Based on that testimony.
Counsel, if that's a close call to the jury, if they're watching her, I mean, they're seeing her, and I understand the deference that we need to consider, but this issue about the bolstering based on the investigator's statement as to her demeanor during the interview, and that should have been excluded. First, do you agree? And second of all, how much did that matter? I guess if you
Right.
if you do.
As Your Honor observed, there is case law, Ludwig case, says that this sort of information, which is common in sexual abuse cases, comes in to help complete the narrative of the case and provide background about the chain of events that led to the defendant's arrest. All this is relevant and non-hearsay information. It's not admitted for bolstering, it's admitted to complete the narrative. And that's what happened here. He didn't get into specific details about how he felt she was credible or anything like that that directly bolstered her testimony. Simply provided a narrative of his investigative process and how that culminated in defendant's arrest and the charges in this case.
Well, you could have gotten into that Ludwig type testimony, Ludwig allowing, and Gross, which is another case I was on that. I decided the Court of Appeals went the other way, but you could have gotten to the Ludwig Gross testimony to explain why the defendant was arrested, how the police got to investigate him without having the investigator describe the victim's demeanor while disclosing. That, I think what Justice Nowak might be referring to is that is stretching Ludwig a little bit beyond its borders.
Perhaps, Judge. And if you were to conclude that, we would say it's harmless error under the circumstances. A single comment about the demeanor of the victim here was harmless given the overwhelming evidence of defendant's guilt centered on the minor victim's credible testimony as corroborated by the DNA evidence. So any minor issue with that forensic investigator's testimony had no effect on the jury's verdict. Lastly, we would just say the sentence here was absolutely called for based on defendant's egregious conduct. This was one of the worst crimes you could imagine. And he received a reprieve when the court sentenced him to only 25 years to life instead of 39 to life, which was the people's request based on the additional 2 counts of rape. And so we would submit that based on the facts and circumstances here, terrible nature of the crimes, no reduction is warranted. Thank you.
Case 656 is People versus Terell Ralph. Terell Ralph. Mr. King, good morning. You may commence your argument, please.
Good morning. May it please the court. Brad Keem for Terell Rolfe. I am just going to submit on my brief unless the court has any questions about the issues that I raised.
Hearing none, thank you. Hollenbeck.
Amy Hollenbeck on behalf of the people, and I will do the same. Unless the court has any questions, I would submit.
Thank you very much, counsel.
Thank you.
We will move to 659, matter of Harper W, 659. We have the AFC remote for this argument. Or counsel, you're here for the appellant?
Yes, good morning, Your Honors. Phil Rothschild, Scott Legal Aid on behalf of respondent appellant Beth. We refer to her as Beth.
We have this Conley down as appellant's lawyer.
I believe it's Cuomo.
We have, I think that's 660 you're talking about.
Oh,
we're on 659. So yeah, this will not take long, I do not believe. So you can sit right there in the front row if you wish. 659, matter of Harper W. The appellant's lawyer, Ms. Conley, has submitted. We have on the calendar Ms. Barnett as the AFC to appear virtually. Good morning, counselor. You must unmute, please. There you go.
Hear me, Your Honor?
Yes, we can.
Good morning. May it please the court, Mary Beth Barnett, the attorney for the children. I need to address briefly the reply brief that was sent concerning my brief. And I'd just like to note that in this case, there were two urine screens that were dumped during the course of the testing of the appellant. One of them was dumped by a caseworker, and one of them was dumped by the appellant, but that one that was dumped was actually, according to the caseworker testimony, her son's urine when she tried to change the urine. And the appellant's brief is correct that I mistakenly cited in my brief to where the caseworker, the page where the caseworker dumped the urine. However, the transcript, according to the transcript on December 7th on page 20, the appellant did dump urine. It was her son's urine. So I just want to clarify that.
No, we appreciate that. Your position is still that we should affirm?
Absolutely.
And this order was issued December of 2023. Is the suspended judgment, are these drug screenings still going on?
Your Honor, I spoke to my client on Monday, but she's only 7 going into 2nd grade. I did not question the appellant about that. So I know that the family lives together, and the children are starting school. However, I don't know if the random drug screens are still going on or not. I had called the court in May, and she hadn't filed, but that's all I know.
You wish to stand on your brief at this point?
Yes.
Thank you. 660, Mr. Rothschild.
Your Honor, I apologize for jumping the gun.
No problem.
Bill Rothschild, Hiscock Legal Aid, on behalf of Beth F. We submit that the denial of request for new counsel was error. Responded in TPR proceedings like criminal defendants.
I'm sorry, could I, oh, we have Ms. Maris. I'm sorry. Go ahead. I didn't see her there. You may proceed.
Have a due process right to counsel that speaks to them, conducts basic investigations, and speaks up for them in court. Here, Beth had none of that.
Counsel, when she requested, I'd like new counsel, it's day 3, it's the April.
Yes.
At that point, she'd had standby counsel for a day plus, for most of the first day, all of the second day. It was unclear to me in the record as to whether or not, when she said, I want new counsel, whether she wanted an attorney to represent her or new standby counsel. So I couldn't tell that from the record. Do you have any comment on that?
Well, given the facts of this case, I think it's pretty clear. I mean, given the fact that the counsel in this case said, I'm going to stand mute, that doesn't inspire confidence.
That was on day 1.
Yeah, that was on day 1.
The request that you're talking about, this day 3 request, I want different counsel. Do we know what she meant, your client meant?
I believe that she meant that she wanted a different attorney. I think it's fairly clear from the record. She felt that obviously there was no request or no inquiry by counsel. But one thing should be noted is that the court, during its waiver of counsel, never addressed this, never said, by the way, do you know you can have a different attorney? And I would sincerely doubt the trial counsel in this case told you that fact either. This case proceeded.
Do I understand it correctly that prior to the hearing, the attorney had never met the client?
Yes, Your Honor.
Had they spoken on the phone?
No, Your Honor.
So no communication whatsoever, and this dispositive hearing is taking place?
Yes, Your Honor.
And now, in defense of the lawyer, I think your client had been in rehab. She wasn't the easiest person to find.
Absolutely, Your Honor. That's
but that doesn't, so I'm not blaming him for the lack of contact, but the fact of the matter is, when this hearing went forward, your client had a lawyer who had never spoken to her, never met her, and requested to stand mute during the entire hearing.
Yeah.
And she's got to be looking at that like, if this were a retained case, I'm not sure that would fly.
Yes, Your Honor, absolutely. And retained, assigned, it shouldn't make any difference. As I was saying, you have the right to an attorney. Additionally, I don't know if this is necessarily a fault of counsel either, but it's pretty clear he didn't review any of the records. That's not unusual in this case because I think the records had only been subpoenaed by the court a week before trial.
Should he have asked for an adjournment so that he could
Absolutely, and we would submit
introduce
that.
himself to? That might not be a bad idea. Hi, I'm your lawyer.
That, I believe that was a clear indication of ineffectiveness in this case. He should have done that instead of asking to stand mute.
I don't see the argument that, you know, when she did ultimately ask for a different attorney on day 3, I don't see the argument that, well, she should have been told that on day 1. She might have done that on day 1. I don't even see that argument raised. But what concerns me about that request, day 3, I want a different attorney. I don't know that your client had an opportunity to give the reason why she needs a different attorney at that point. It seemed like there were a lot of interruptions in the record.
Absolutely, Your Honor. And as I started to say, this case was proceeding very fast. This judge is known for going very fast. The counsel was assigned in December of 22, didn't make the first appearance until January, actually didn't make the first appearance January 12th. During that appearance, they're talking, oh, well, let's put this case on for trial for March 31st. Instead, the trial is held on February 15th. Now, when counsel says, I want to stand mute, the court says, okay, we're not going to have that. This case is going to go on.
But you would acknowledge Judge Serio handled that part of it exceedingly well. She castigated him, dressed him down.
Absolutely. But during that castigation, she also made it very clear, this trial is going to proceed whether you've met with your client or not. We're going to go ahead with this thing. I believe that her exact words were, well, you've had a month and a month is forever in family court. Your Honor, in these circumstances, a month is not forever when you don't have access to the documents, when you can't contact your client who's in rehab because of HIPAA laws and all of that going on. The court repeatedly said it was not going to brook any type of delays. Given those circumstances, you know, it's understandable that she felt that she had no attorney in this case. When she finally did ask for one, the court's rationale, well, you made your choice. I don't believe that was a knowing, voluntary, and intelligent waiver of counsel in this case, because she didn't have an attorney to begin with. And in this situation, we would feel that the court erred in summarily denying Beth's request for substitute counsel based upon her choice. The right to counsel is constitutionally guaranteed, and courts, trial judges have an obligation to ensure that that right is upheld. And I would submit, and I know that there's discussion in the other briefs about what was happening and all the proof against her. This court in Brown versus Gandy deemed harmless error inapplicable when there is a showing of ineffective assistance of counsel, deprivation of counsel. And I believe that goes along with the saying, if you can't trust the process, you can't trust the result. And I believe you can't trust the result here. We would ask, because of the impingement of rights, that this matter be reversed and remanded before a different judge.
With respect to ineffective assistance of counsel, is there anything you can point to that the attorney should have done differently?
Yeah, I think he should have requested an adjournment to start with.
The failure to request the adjournment on day 3? Or
no, on the day,
the adjournment on day 1?
On day 1.
I'm going to stand mute.
Yes, on day 1, when all this was happening, basically put her in a situation where I've got someone who isn't even going to speak up for me. So someone who hasn't read the papers. If that had been done, if he'd requested an adjournment and denied it, I'm sure that we would be in a different situation here, and this court would feel obligated, in fact, to reverse because of the denial of the opportunity to prepare a defense.
You would agree, would you not, that it's irrelevant if we look at the record and say she would have lost anyways, even if she had Perry Mason, the best lawyer ever. That's not, we can't consider that. In determining meaningful representation, we can't, there's no harmless error. We can't say there's all this other evidence. Was there meaningful representation, even in a losing cause?
Yes, Your Honor, this court said it in Brown versus Gandy. And I would submit that because to protect the process is to protect every individual's rights, and I would submit that's required here.
Right, thank you.
Thank you.
Ms. Cuomo is remote.
Attorney Lisa Cuomo on behalf of the county. May it please the court, if we're only focusing on the ineffective assistance of counsel, I would note that the appellant never appeared in court physically throughout the entire proceeding. In fact, she did not appear for the first appearance, and then there was substituted service on the second appearance, and the court proceeded forward at that time. I would note that her counsel did speak to her via phone at the first rehabilitation place that she was currently at that time. And as the court is aware, when you review the record, she moved around to various different rehabilitations, basically never appearing once for the purposes of the proceeding. So she did have an opportunity to talk to her attorney. They were able to communicate. He was able to get the phone number for where she was and could have effectuated a call there. However, ma'am kept moving to different facilities. And he did, again, he engaged in the trial, and she asked him to then come back in during the dispositional hearing.
All right. Thank you, counsel. We'll hear from Ms. Maris now for the child.
Good morning, Your Honors. May it please the court. Susan Maris, attorney for the children who are now 4.5-year-old twins. They were removed from the mother when they were 6 months old. They have lived in the same foster family for the last 3 years. If this court affirms a permanent neglect and TPR, the foster parents will adopt these children and give them the permanency they so desperately deserve. Just going to the I did mention in my brief that the appellant abandoned the issue of the finding of permanent neglect because he didn't brief it. The only issues he raised were the ineffective assistance of counsel as well as the suspended judgment. I'll just go to the ineffective assistance of counsel and the other issues. The burden is on the party, the complainant, to prove that they were denied meaningful representation and they were prejudiced by that. There is absolutely no evidence of prejudice in this record. Appellant indicates that the attorney didn't meet with the client. He probably couldn't find her. She was served by substituted service because the Department of Children and Family Services couldn't find her.
Well, they found her by the time of the hearing, and Mr. Rothschild's argument is at that point it's incumbent on lawyer to say, you know, I kind of like to talk to her before we have this trial. Can I have a brief adjournment? He says that was where the lawyer was ineffective. And among others, then he just offered to not say anything during the trial, which was absurd. But fortunately, the trial judge didn't let him do that.
Correct. And he didn't meet with the client before the trial, but he did meet with the client during the trial. And at that point, after he met with the client, he indicated, or the client indicated, that she wanted to represent herself. The judge—
You can't really blame her. If you were in her shoes and you had a lawyer you never met before and the trial is starting, and then you're looking at your lawyer who you didn't pick, who's never even called you, and says, yeah, I'm gonna not say anything throughout the whole trial. I'm just gonna be here. I think any normal person would be like, yeah, I'll do it myself. It's better than this.
Well, I think because she defaulted on the first appearance and the family court judge sent it down for an inquest. So to be ineffective, there's got to be no reasonable basis for the counsel's presumed shortcomings. In this case,
no strategy, right? So,
but in this,
what would be the strategy?
I think
not asking for an adjournment.
It was sent down for an inquest, so he was going to stand mute, which is a strategy. But nonetheless, he did represent her. He didn't stand mute. And as far as the request for, and the judge did ask why during the colloquy, why she wants a new attorney, and the client didn't answer that question. The mother did not answer that, and it did go fast, but the court clearly made her aware of the danger of proceeding without counsel.
The court tell her that she could permanently lose her children when her other children were living with her sister or another family, as opposed to freeing the twins for adoption. Did the court let her know the severity of that?
I think the court did. The court did tell her that you're not going to be able, I'm not going to help you. You're going to have a difficulty. There's a danger in proceeding without counsel.
But not saying what the danger was. Just that there's a danger in proceeding without counsel when your only choice is to proceed with somebody who says they're gonna stand there and be quiet and not speak on your behalf.
But that changed, I think, Your Honor. He did. And as far as and then he did zealously represent her. He made objections. He did zealously represent her. Whatever he said, I think, is not the point. He did represent her. And then on the last trial in April, she asked for substitute counsel, but there's no absolute right to a new attorney. There has to be good cause. On this record, there is no good cause.
But is there nothing on the record because the judge just cut her off? That was the April proceeding. I believe it was the dispositional phase.
Correct.
The judge didn't really let her say anything. She just kind of went off.
Well, and so I can't speak to that directly, but I think the mother was calling the court before the appearance and requesting new counsel. And I think the court rightfully determined that these were delay tactics by the mother. She engaged in a lot of delay tactics by checking into rehab every time there was a court appearance and then checking out and checking back in. And I think the court realized these are delay tactics. But the court, you're right, the court did say you're not getting new counsel, but I don't think the mother demonstrated good cause for new counsel. The attorney zealously represented her. Unless there's any questions, I'll rest on my brief.
Thank you.
Thank you, Your Honors.
Case 661 and 662, matter of Maverick V and Tyshawn G. 661 and 662. Greenberg, we are waiting for Mr. Mannion, and he is now with us virtually, so you may proceed.
Thank you, Your Honor. I am Charles J. Greenberg, representing the appellant, Chantel K. in her appeal from the neglect finding that she had directly neglected the elder of the two children, Tyshawn, and deliberately neglected the younger of the children, Maverick. Before I begin the substantive argument, does the court have any questions about the jurisdictional issue? Because I don't think the department may have raised that it's not properly preserved. Our argument that it is preserved because we're arguing the weight of the evidence and not the sufficiency of the evidence. Sufficiency does require preservation with the requisite motion. But if there are any questions concerning the weight and the court's jurisdiction over that, I can go directly to the
If there are no questions, I wouldn't necessarily take that as a ruling that there's no jurisdictional issues, but you can proceed to your next argument.
Okay. Well, the argument was whether the direct neglect had actually occurred. The main witness for the department was a woman named Vinovsky. I don't know if I'm pronouncing it correctly, but she did not. The essential allegation, Your Honor, that my client had held up a knife directly to his throat or his neck because he had not adequately done his homework. But the exact quotes from when you go through the trial on page 226 of the record, the exact quote was, "I believe it was our second interaction with Tyshawn. He did report there was one instance where Chantel, did hold up a knife to him and threaten him with it, but it wasn't to his neck or his throat or anything like this. She was just held up a knife, but there was no testimony as to what kind of a knife this was." And when you go through the record, the word neck and throat never actually appear at the
When did she allegedly do that? When did she allegedly hold that knife?
Well, I think the allegation was when she came home from school. When he came home from school, he wasn't doing his homework or doing anything else. That was. I don't know the exact date as to when it occurred, but just to give you a reference point as to how old he is, he was born on September 9th, 2015. So he's currently 9 years old. So this occurred a few years ago.
I meant in terms of when, based on her mental health issues.
Oh, the mental health issues.
Yes, was it at a time when her mental health status was questionable or when she was allegedly well?
Oh, the allegation, part of the allegation was that she was not compliant with her mental health, but I think that the testimony showed that she was complying with her mental health. So my client does have the mental health issue that she's supposed to be attending, and that did form a portion of the allegation against her from the department. And it did state at the proof of the trials that both was complying, at least at the time of the trial. Whether she was complying with it at the time that the incident was made, but a separate issue. Did that adequately?
Yes, it does.
Okay, good. But we also know that Mrs. Vinovsky did testify that Taishan had no concerns with Chantel. We'd also ask the court to look at the quality of the statement of the knife. Did Taishan tell that directly to Ms. Vinovsky? I'm sorry if I'm mangling her name, but is that because 1046 AVI does give the caseworker can repeat as to what the child directly told her. But if this child told another person and that other person told the caseworker, then that would be a double hearsay, which I don't think is covered by 846 AVI of the Family Court Act. So I think when you look at the evidence in its totality, not just some of the specifics, look at all the trees in the forest, not just the specific trees, if you will. Not the best analogy, but our position is that there was no evidence by a preponderance, there's no preponderance of the evidence that she had neglected Taishan, and by logical extension, if there was no neglect of Taishan, there was no derivative neglect of Maverick.
We understand the argument. We appreciate it.
Okay, thank you, Your Honors.
We can move on to Mr. Mannion.
Thank you. Good morning, Your Honors. May it please the court, on behalf of the Erie County Department of Social Services, Benjamin E. Mannion. Before I begin, I would like to just say there is a correction to the citation for one case on page 25. This goes to the department's first point, which is that this issue is not preserved, as the language of appellant's brief and the actual arguments that are made do not actually seem to assert that there is a weight of evidence claim. It seems to assert that there's a sufficiency of the evidence claim, which, as this court is aware, in the case of Syria W, which is a Fourth Department case, that a sufficiency of the evidence claim must be preserved by a motion at trial by the respondent to move to dismiss for lack of sufficient evidence. The actual text of appellant's argument here would seem to suggest strongly, and I would urge this court to view it in this light, that is a sufficiency of the evidence argument that is being advanced, not a weight of the evidence argument, as appellant's counsel asserts today. However, if the court finds that the argument is preserved, the department presented more than sufficient evidence, which was uncontroverted and unobjected to at trial, contrary to what appellant's counsel has advanced before this court this morning. The case manager, who was assigned to the case from the outset, followed it from the outset, did testify to the fact that Taishan informed her that the respondent did present a knife, did hold a knife up to him, which it absolutely stuns me that there would be a difference, that if the respondent in this case, or appellant in this case, held a knife up to the child's neck, it's neglect. But anywhere else on the child's body, and it's not, which is what appellant seems to assert and ask this court to believe, which stretches credibility at this point. Beyond that, though, Your Honor, as to the evidentiary issues, who testified to what, who told who what, who reported what, none of this was objected to at trial. It's raised for the first time on appeal. Therefore, it is not properly before this court. And as to, wrapping this up, any weight of the evidence, the department's contention, as it was in its brief, is that the department presented more than sufficient evidence to present the trial court with a sound and substantial basis for its decision. And I would ask this court to affirm the trial court's decision, pending any questions.
Thank you.
Thank you.
Ms. Cavagnero?
Yes, Your Honor. Good morning. May it please the court, Melissa Cavagnero, attorney for the child Maverick. I do not contest this court's ability raised on point 1 of Mr. Greenberg's appeal that you have the ability to review the evidence. So moving on to point 2, I would argue that the lower court made a proper finding that Tayshion was neglected. There were not only his statements, which were sufficiently corroborated because he personally told the caseworker at the second meeting that the mother held a knife up to him. And I would agree with Mr. Mannion that any holding up of a knife would constitute neglect. There was a myriad of other actions by the respondent appellant over the almost 4 months that DSS were visiting her. She made numerous suicide threats, not only to the caseworker. There were threats observed by the caseworker in the respondent appellant's home, and threats were made to, at the time, the safety plan custodians of Tayshion, who ultimately became the 1017 placement for him. Based upon that finding that Tayshion was neglected, there was an appropriate finding that my client, Maverick, was derivatively neglected.
Thank you for coming in.
Thank you.
Okay, 633.
663.
Sorry, yeah, 663. Thank you. 663 is Lionel Casas versus Crystal Day. 663. The appellant has submitted, as is respondent. We have the AFC. Thank you for coming in. Good morning.
Good morning, Your Honor. Susan Maris, attorney for the child who's now 10 years old. Because appellate's on submission, unless there's any questions, I'll rest on my brief.
I do have a question. With respect to subsequent proceedings, my understanding there was a reference in a brief, could have been yours.
Yes.
About a modification petition the mother filed in Bronx County Family Court. My understanding is that's still pending.
Correct, Your Honor. The trial's scheduled for December 16th.
December 16th trial, and that's the mother's in Greenwich, Connecticut.
Stamford, Connecticut.
I'm sorry. Okay, Stanford. And the father's still in the Bronx.
Correct.
And that petition, the mother wants primary physical residence in Connecticut?
I did not see the petition, Your Honor.
All right.
So I don't know.
So if you hear of that case being resolved, there's some mootness issues that may arise.
Okay.
If we have a subsequent custody order, if you could let us know, we'll probably have a decision out here before the trial date anyways.
I think so.
If it settles or something, if you could just let us know.
I will,
But
Your
your
Honor.
position is you're still in support of the trial judge's determination here.
Yes.
All right. Thank
Okay.
you.
Thank you.
664 is Council Financial Holdings LLC versus Sullivan Law LLC.
Good morning, Your Honors. May it please the court. Sean McPhee of Phillips Lytle LLP for the defendant's appellants. I will be brief this morning and respectfully submit that Justice Chimes erred in 2 distinct ways, so her order should be reversed for either reason or for both. First, procedurally, Judge Chimes should have never even considered Council Financial's motion for leave to re-argue Judge Walker's order, because in doing so, she violated CPLR 2221A based on Council Financial deliberately setting the return date for that motion to a date subsequent to Judge Walker's departure from the bench, and it did so knowingly.
But it was a timely motion though, right?
The motion was timely. It was filed on June 29th, but Justice Walker had previously notified counsel that his last day on the bench would be July 31st. So there was more than a month left before Judge Walker was departed. And they set the return date deliberately for a week after his
Right. So
departure.
you're suggesting they may have been judge shopping.
Absolutely.
But at this point, you get the 5 of us.
Correct.
So on the merits, whether it was Judge Walker or Judge Chimes, why don't we address the merits before us?
I'm happy to do that, Judge, and I will, but I'd just like to point, and we cited this in our brief, this court's precedent in a case called Matter of Right versus County of Monroe. This court reversed and the exact same procedural posture and order granting re-argument that was made by a subsequent judge because the judge was sitting in appellate capacity over a court of coordinate jurisdiction. This court's precedent supports my point one, but
Without getting to the merits in that case, you're saying the
Correct.
court just said that's wrong procedure. We're not even going to address whether the court got it right.
that's correct. And also, Counsel Financial suggests that matter of right is no longer good law somehow because it was decided before the adoption of the IAS. That's not correct. In fact, the first department and the second department have cited matter of right favorably decades after the implementation of the IAS.
So could you have moved by order to show cause to be heard in front of Judge Walker if you wanted it there sooner?
It wasn't my motion, Judge. We won our motion to renew. Counsel Financial then sought to re-argue the granting of the motion to renew.
Right, but I meant, could you have brought an order to show cause to make your objection to counsel doing that?
Well, not on his motion. I can't make an order to show cause on a motion that's brought by notice.
You could have done something, and my read of the record is nothing was done to try to get it in front of Judge
To get
Walker.
in front of Walker.
Well, Judge, I would respectfully suggest it's not my obligation to reschedule his notice of motion when it's still, let's look at page 12 of the record. It's clear what they were doing. The motion was made, the judge that is said to be returnable before, the Honorable blank JSC, they knew what they were doing.
You're suggesting that strategizing is not part of the lawyer's role? And then
Strategizing
on your end might also then be countering in some way. And then, as the justice presiding indicated, now as we're here, we can really kind of examine the merits. And don't forget that Wright also says that when a judge retires, it's also appropriate for the case to go to another judge. There's two elements to Wright, but let's get to the merits as far as I'm concerned.
So by reversing Judge Walker's May 2023 order, Judge Chimes also erred on the merits. In Counsel Financial 2 versus Bortnick, this court expressly determined that CPLR 3213 is unavailable with respect to the exact same instrument that we are dealing with here. They are identical. Counsel Financial has admitted as much in its brief to this court on page 20. It admitted as much below. It's in the record of page 739. We're talking about the exact same instrument.
Right, but wasn't there another agreement? Bortnick, I was on both.
I know you were.
Bortnick and I was on the prior one.
Correct.
Bortnick, as I recall, the guarantee may have been the same, but there was another agreement with respect to fees coming in, contingent fees. So it wasn't just the examination of the guarantee. You had to look beyond that to get to the assignments and money. And so it wasn't, that's important because we CF'd the first Counsel Financial case, Sullivan. And so we looked at it. Maybe our distinction wasn't valid, but it's not like we overlooked it.
Correct. I don't think it was a CF, Your Honor, respectfully. It was with respect to one of the arguments that was raised in both Sullivan and Bortnick, that there was more required under the guarantee than just payment. It also required performance. And we understand that how the court has ruled there. But what we're talking about here is 3213 speaks in terms of instruments for the payment of money only. We're talking about instruments. We have the exact same instrument. They're in the record. I have them printed out here. There's no question they're identical. My position is,
I don't think anyone disputes that.
okay, my position is,
do you have, how far outside that instrument do you have to go to get to the issues here?
I think that the best example of that is in their own moving papers on the motion for summary judgment in lieu of complaint. Okay, this is the best example to answer your question. Paragraph 41 of the affidavit of the Chief Operating Officer of Plaintiff Counsel Financial. This is page 37 of the record. They say, defendants owe $535,000 in current interest. Now that's page 37 of the record, paragraph 41. The very next paragraph, paragraph 42, this affiant says she's attaching as Exhibit G to her affidavit a statement that provides a, quote, a complete accounting of the amounts owed, including interest. Now that exhibit is found on page 94 and 95 of the record. And it says the current interest is only $119,000. So their very own moving papers reflect a $411,000 discrepancy in the amount of interest. If we don't need extrinsic evidence to delve into that discrepancy, then how can we talk about
the Sullivan case or in the Bortnick case?
This is in our case, in our Sullivan case, this record before this court.
That case has been decided. And we said that the de minimis extrinsic evidence was okay. A 2-page summary of what the amount owed was. And Bortnick, as I understand it, having looked at the record, there was this offset agreement that had been entered into, I think it was Bortnick, I forget which lawyer it was, including the fact that that offset, which was agreed to by Counsel Financial to circumvent the money going to the law firm, it was used to pay down, I think it's Bortnick's, and there was even an interpleader action based on that offset agreement. So as I read Bortnick, Mr. McPhee, just to tee this up for you, as I read Bortnick, we specifically referred to there being more de minimis extrinsic evidence in Bortnick than there was in Sullivan based on this offset/credit agreement that Bortnick was afforded. That seems to be the distinction between the two. What do you think?
What I think, Judge, is if we're looking at discrepancies or questions as to amounts in order to determine liability, then it was the same in Bortnick and it's the same here. And like I said, the best evidence is their own moving papers that have this $411,000 glaring discrepancy that needs to be explained through the use of extrinsic evidence. Hasn't been explained. Judge, if someone took a judgment against you and they just put numbers in, $535, $119,000, we're talking about real money here. You should have an opportunity to join issue and let's take some discovery on these numbers that are in their own moving papers. They're not discrepancies that I've created. They're discrepancies in their moving papers. In this court said the moving papers is the key in Bortnick. That's what this court held. Defendant's liability, this is a quote, defendant's liability cannot be ascertained without resort to impermissible extrinsic evidence outside the financial instrument. The same is true here.
So your point ultimately, I think, has to be, Mr. McPhee, that in the 7 months between Sullivan and Bortnick, our court abrogated Sullivan, and therefore that served as the basis of your motion to renew, premised on the argument that there was a change in the law with respect to what constitutes an instrument for the payment of money only. That has to be the essence of your argument on the motion to renew that we're looking at in the context of a motion to re-argue, correct?
I would say procedurally that's correct, but more fundamentally, what this court decided subsequently in Bortnick is that this particular instrument does not qualify for CPLR 3213 accelerated summary judgment treatment.
So in Bortnick, we changed our minds. We abrogated Sullivan. That has to be your position on the motion to renew, correct?
That is correct. That this particular instrument that is admittedly the same does not qualify for 3213 treatment.
The judgment that was made here, which figure was used? The $500,000 figure or the $100,000 figure that you quoted?
The $530,000 figure.
So you're saying that the affidavit that included the 2-page, I refer to it as an account summary. You may refer to it differently.
They call it a complete accounting.
All right.
Exhibit G, pages 94 and 95.
So that didn't support the figure that was represented in the affidavit.
It does not on its face.
I see.
All right. Thank you, Mr. McPhee.
Thank you, Your Honors.
If it please the court, I will try to be brief. First of all, it is handy that Justice Lindley was on both Sullivan 1, I'll call it Sullivan 1, and Bortnick.
No, I could have got them both wrong.
Pardon me?
I could have got them both wrong. That's possible. Well,
no comment. But you've already spotted the fact that Bortnick is fact sensitive. It applied the same standard that Sullivan did. It cited Sullivan with approval. It cited what Bortnick said is Sullivan stands for the prospect that you can apply, you can rely on de minimis extrinsic evidence. And here, and you look at these cases, you always have to have an affidavit of a financial person. I mean, how else do you authenticate what's going in? How else do you state it? So all these cases have an affidavit. This case, Sullivan had an affidavit. And the affidavit.
Savina, sorry to get you off your game real quick, but go back to when you're ready. But looking at Bortnick, it seems to me what the court was looking at, particularly at the end of the decision there, was the fact that there was this seemingly separate offset or credit agreement that Bortnick took advantage of, as I already described, circumventing the payment to the law firm. So the court looked at that as being more than just de minimis extrinsic evidence. And it's not just, as I read Bortnick personally, it's not just the amount due. It's the fact that in addition to this instrument for the payment of money only, the guarantee, which is the same in both, that in addition, there was this separate extrinsic evidence, which is more than de minimis in the forms of the offset agreement. It's not just the amount owed. I know you have your two-step process that you keep articulating to try to rationalize the two, but it may very well be that Bortnick, seemingly, given its discussion of the last paragraph or so, that it was really based on the idea that there was a separate agreement.
There was, here's what they did, and it's in the record on appeal of which you can take judicial notice. Bortnick had left the law firm. Counsel wanted money steered from his former law firm to counsel. So counsel said, look, Bortnick, if you steer that money to us from your old law firm, we'll give you $1 for $1 credit. That's a separate side agreement. That's independent of the loan agreement. And I hate to say it, I think Justice Lindley got it right. I mean, that is outside 3213. It wasn't, there's the note, and then there's this whole other arrangement with giving credits, and it had to be explained. It took a lot of paperwork, and you know, it's being litigated now, and there's discovery because it wasn't the classic, there's a note, somebody states the amount due, but let's talk about the amount due. This is the second bite by reason of this allegation that Bortnick changed the law of the state of New York. This is a second bite of Mr. McPhee on the amount due. And if you go back to his brief in Sullivan 1, and Sullivan 1 was decided in 2022 on pages 25 and 29, he talks about the calculations. There is a decision by this court ratifying the calculations sworn to by Miss Megan B. Payne. She's the person swearing. She states the amount. This court 2 years ago said, we're sustaining judgment. I think that's law of the case. You can tie out the numbers on the different charts, but I don't think there's any need to, because I think that's been covered. The other thing that's telling is there is no counter proposal by the defendant as to what should be the interest and late fees. My opponent doesn't say, but the number is really this. He simply says, I think there's an inconsistency, and there isn't. But
so that issue, this distinction between the two figures, that was before this court previously.
Exactly. And if you look at the decision, it was based on the briefs. If you look at Mr. McPhee's brief, he talks about the amount as he tried on pages 25 and 29. If the court has concerns about Mr. McPhee's usury argument, there's a brand new case that I think puts it away if there's any doubt. Is there concern where I should address usury?
I think we have it.
Thank you, Judge.
Thank you very much. 665 is Aaron Law, PLLC versus the Rochester City School District. Both counsel are remote. Aaron, good morning. You may proceed.
Yes, good morning, Your Honors. Thank you. So this case is relates to a FOIL request. The judge in the lower court ordered a decision, which in a way was ambiguous because the FOIL request was for multiple records relating to a police shooting, including various communications. That ambiguity sort of got highlighted in the proposed judgment that was filed to His Honor in the lower court, subject to the decision. The court ultimately rejected our proposed judgment and, sort of left it ambiguous. And I think it's, highlighted in respondent's letter with their counter proposed judgment that their position was the only document subject to the court's order for production was the actual video. So in terms of our appeal is that the court made a mistake in not granting the other portions of our document request, which were never withdrawn, articulated in the petition, and further articulated with greater detail in our opposition to the cross motion. It never really got fleshed out because as opposed to submitting an answer, which our contention was the respondent should have done because there were clear issues of fact, respondent just submitted a motion to dismiss.
Specifically, you're talking about communications with the Rochester Police Department as well as with parents and with the media, some of which you received, but you're claiming there's more that you didn't receive.
So, Your Honor, we actually didn't receive any at all following the commencement of this action. What happened was we were sort of deprived of the administrative process because FOIL mandate some type of interactive dialogue known as a FOIL appeal process. So what happened was we made the request. The request was constructively denied. We followed up with multiple emails. Finally, they said, okay, here's a general press release that we sent out, and the rest of your request is denied, and basically stamped on, you know, half the FOIL exemptions under statute without indicating any factual basis as to why those exemptions should apply.
Well, they seem to be arguing now that it's too vague and there's so many that they don't know if you're asking for every communication to every student from every teacher. Could it was verbal? Is it just email, letters? And almost impossible to comply with everyone in the city school district, every communication to say a parent or a child. What's your response to that? I'm not sure that was raised below. But what's your response? It does seem like that would be, there would need to be some clarification. What exactly are you looking for?
I agree with you, Your Honor. So I have two things I'd like to say in reply. One is that obviously, you know, in this regard, the school district is centralized. So there was an office that dealt with these communications. So it's not like, oh, let's ask the custodian of the school, did any parents reach out to him? There is sort of a centralized venue. The second thing is, you know, there are these regulations that are promulgated that have the effect of law, NYCRR 1401, that were as recent as last year amplified by the second department in the matter of Goldstein versus Mamaroneck that says, look, if there's an issue with clarification, so that's something that the agency has to address with the petitioner. So to the extent that there is an ambiguity, clearly it can't be held against petitioner. I mean, that would be tremendously prejudicial and unfair. First of all, if they would have satisfied their obligation, we would have been able to have some type of dialogue and add clarity at the time. Secondly, had they have, forget about the regulations, but had they have complied with the statutory mandate of public officers law and allow us to administratively appeal, we would have said, hey, where's the other stuff? And it would have been fleshed out and the dialogue would have emerged within our administrative appeal, which is clearly what FOIL envisions. So to the extent that there is more clarification needed, so, you know, I guess that would, we'd be asking for some type of remand. We think on its face, it's pretty clear, again, because, you know, we're not asking if any parent said to a custodian, hey, did you hear anything about this? You know, there's a centralized type of thing. We imagine where this stuff goes through, or a certain amount of custodians that would have it. And also in terms of electronic records, I think the courts have been extremely clear, including this one, about keyword searches. So I can appreciate that there may be a need for clarification in regard to those aspects of the request, but I just ask that since we never had that opportunity, that should be subject to a remand, not held against us. The last part of our appeal is we believe that the trial court made an error in failing to trigger the fee shifting provision, both the mandatory and discretionary. The mandatory, because as it states, it's mandatory. The legislature in 2017 explicitly changed the wording from may to shall. Obviously, still, if they had a reasonable basis, but here they had no reasonable basis to deny everything for multiple reasons. First of all, the court did properly find that the video, you know, obviously with blurring out and de-identifying anybody in the video, is subject to redaction, which is a product of well-settled case law going back literally from 30 years. So the appellate divisions throughout the state have said that this is not an education record that would be subject to FERPA, and therefore by extension, the exemption of 87-2A. And furthermore, FERPA in itself statutorily says that any time you could de-identify, you're never within FERPA. So within FERPA itself, there's a de-identification clause. So between that and the 30 years of case law, and this goes really to the cross appeal, we believe 100% that the court got it right. There was absolutely no basis for citing a FERPA, meaning the case law says in the context of the mandatory fee shifting provision that you need a reasonable basis, and that has been consistently interpreted by all four appellate divisions that you're relying on a case. You look at the well-settled law, and based on the well-settled law, you know, you could get it wrong. But that's not what this is. This is a case of an agency that just wanted to obstruct and not comply with FOIL. And we see that in that it was initially constructively denied. and that one thing which is extraordinary, delays are not extraordinary, but depriving the petitioner of the appeal process is. So I think, you know, contextually, you see here that both the mandatory one, there was no reasonable basis, and under the discretionary, even if there was a reasonable basis, the declination to award attorney's fees would have been an abuse of discretion because of the statutory deadlines that were missed by the respondent. I'd also just like, I'm sorry.
Mr. Aaron, how do you respond to the school district's argument that your office has continued to expand the requests, particularly with respect to the communications throughout this whole process?
There's nothing in the record. There's nothing in the record that supports that at all. We've never changed it. It's subject to the original FOIL request. We never put in a modification. And in fact, it makes no sense because there was no appeal. There is no opportunity for us to modify it. So, you know, that's just an assertion made by them that's empty. We've never modified it. We asked for it and we didn't get it. And we didn't even have an opportunity to clarify to the extent that there was an ambiguity in what's being sought. So, you know, I don't think that there's any basis for that in the record or out of the record. Just in terms of the other contentions in terms of exemptions, again, under FOIL, every court's been clear, including the Court of Appeals, that you can't just stamp on titles of exemption. They need factual support in relation to the context. There's been no factual support provided in any of the papers and in the record. Now, specifically, their interference exemption, it doesn't begin. Why? Because statutorily, FOIL says that whenever you want to raise the law enforcement exemption for pending investigation is a predicate, you have to reach out to the investigatory agency and confirm at the time of the request that disclosure would interfere. That was never done here. It wasn't done at the time of the request, and it wasn't done later on. What the district cleverly did in its answer was contrive an email chain, and you see, I think it's one day before the answer was placed, where PD says, yeah, we're investigating this and nothing should be released. It doesn't say it would interfere. It doesn't explain any purported interference. It doesn't say that they were asked, you know, a year earlier when it was requested. So from a statutory analysis, they didn't comply with the statute. Failure to just comply with the statute and make up your own set of rules clearly doesn't constitute a reasonable basis.
Thank you, counsel. We'll move on to Mr. Sheriff.
Good morning, Your Honor. May it please the court. This is Jeremy Scher from Bonshank and King for Rochester City School District. What really strikes me in response to Justice Nowak's point is that we still don't know what this FOIL request actually seeks. It does continue to expand because the petition didn't say how the response from the city school district was deficient. The response to a motion to dismiss said that there must be unproduced communications from, quote, the school, which presumably is Franklin High School. And now it seems to be that the Aaron Law's position that it wants every communication about this school shooting, not police shooting, school shooting, across the entire district with all its thousands of staff and tens of thousands of parents.
Why not just give them what you know they want, which is the communications from Franklin? Start there.
We did give them what we...
You have everything, all the emails and...
I can't make that... I'm sorry, Your Honor. Please continue.
So you're saying you complied with the communications from Franklin itself, but then it expanded and they want communications outside of Franklin High School?
No, Your Honor, that's not what I'm saying. What this district did is it got a request saying produce communications with these various entities, and the district thought it was complying with that request by producing district-wide communications with the police and parents. And then then we get into this issue of a vast amount of most of the arguments that counsel is making are not preserved for appeal because there are no multiple emails with the district in the record. That's news to me. None of that's in the record. There's no argument in the record, and it was never preserved for appeal that there was some sort of deprivation of a right to an administrative appeal that somehow prejudiced Aaron Law. Aaron Law, instead, what the record does show is that Aaron Law went directly from receiving a record production from RCSD to a lawsuit. it never came back and said, these records do not cover our request. We want additional communications from anything. Instead, what Aaron Law has done is gone straight to litigation and, as Justice Nowak said, expanded its request. And we never got to a point. We were never at a point where they came back to us pre-litigation and said, there's a mistake here. We want communications with the school. The statement that counsel made about all these documents being in some sort of centralized office, that's not in the record. The issue of the court below issuing the wrong order, that's not in the record. The concept that there's 30 years of case law interpreting FERPA consistently with Aaron Law's position, that's not briefed anywhere, and it's simply not true. So I'm taken aback by the amount of statements Aaron Law relies on that are simply not in the record or not correct. And it's all to misdirect from the point that to this day, Aaron Law has never plainly stated what it wants RCSD to provide. It wants litigation. It doesn't want an actual clear request so that it can get its documents. So the remedy here is very straightforward. If it has a clear request in mind, it can just make it. Going through this long process of litigation over a request that Aaron Law has never defined, not even to this day, is not consistent with the purpose of FOIL. And speaking of FOIL, I want to emphasize how this case goes to the heart of the exemptions from FOIL. This is, again, a school shooting, not a police shooting, a school shooting that traumatized children attending school who escaped being shot escaped with their lives by pure chance. And this was an individual who tried to shoot students because he thought they were witnesses to that person shooting someone else. And to the public's knowledge, that person is still at large.
But Mr. Shirley, the effect on the public and the effect on the students, that wasn't raised as a reason why these disclosures shouldn't be turned over, that it would be detrimental to students. My list has that it violated FERPA, that it's going to interfere with a law enforcement investigation, and that it could endanger life and safety. But the endangerment of life and safety, from my reading, was that it could somehow open the door to another shooting, because we could see how they entered, that kind of thing, that essentially almost piggybacks interfering with the police investigation. Is that what was raised initially, or is there more?
Your Honor, I agree that those points were raised initially, but there's one additional point, which is that disclosure endangers witnesses to the shooting, including the students who were shot at.
Well, can't that be redacted? Judge Valeriani, wasn't there a provision that could be safeguarded, the identities? And first of all, this shooting took place January 5th, 2023. Is the investigation still ongoing? Any arrests been made?
All I know is what's in the public record, which does not reveal any arrest or closure to the investigation.
Right. It doesn't seem like it's a newsflash to anyone that Franklin or any high school would have security cameras anywhere.
That's correct.
So that doesn't seem to be any justification. And if the identities are not disclosed, I don't know. I would assume the person who did the shooting knows who he's shooting at, but we will take a look at all your arguments. They're laid out very well in the brief, and unless you have anything further, we will move on to the next case.
Does the court want the citations for the things Mr. Scher said I made up?
Yes, you can. We don't have rebuttal here, but you can put them in a post-argument submission if you wish.
Thank you very much, Your Honor.
Thank you. Case 666, Emeris, New York LLC versus Brookstone 8 LLC.
Ready for the appellant Emeris, Your Honor.
Yes, we're waiting for co-counsel. Mr. Moskowitz and Ms. Rubel. All right, everyone's here. Mr. Shears, the appellant, you can commence your argument, please.
Thank you, Your Honor. And again, may it please the court, Jeremy Sher, Bonshenick, and King for appellant Emeris. This case is not not terribly exciting from a legal standard because it goes to the heart of how contractual disclaimers work in real estate purchase transactions, which is extremely well defined in New York. This is a case with involving a $16 million real property purchase by Brookstone. Brookstone, in its own words, provided a quote 11th hour bid end quote on this property. There's no allegation that it performed any due diligence on the property, and it signed once it won its bid, it signed a purchase agreement stating that it was not relying on anything in purchasing the property other than the contract itself and any signed disclosures by the seller, Emeris. There is no allegation here that the seller said anything false in its contract or in a signed disclosure. Instead, Brookstone is claiming it relied on a broker that was not its own, making its reliance solely at its own peril. And it was
Mr. Sher, we have the argument.
Yes.
We know there's an allegation and that there may be an issue as to whether the broker was acting on your client's behalf or not. But we have an allegation that he was. And in my view, I mean, not only do we have the short time frame, but we have this attachment with the architect's plans as to how we can add additional units here. And then, of course, that was used as the incentive for the bid. When you couple the attachment along with the bid and then along with the time frame, how do we not even have an issue of fact on justifiable reliance?
Your Honor, I agree that that is Brookstone's best argument, and it still fails because of the disclaimer. When Brookstone comes in without due diligence as a sophisticated purchaser and says it will not rely on anything outside the contract itself, and Emeris has signed disclosures, then it has to abide by those representations, by that agreement,
Right.
that disclaimer.
Well, what Judge Doyle in his decision, very well written decision, I might add, talked about is these issues can be addressed in 3212 motion for summary judgment. This motion's 30 is to dismiss here. And as I understand your argument is that the Brookstone could have known that these floor plans couldn't have been approved by the zoning ordinance if they had just looked. It's a matter of public record. But the time the bid was coming to an end, and that if the inducement to bid higher, hey, you can get more apartments in here, was made 5 minutes, 3 minutes, 2 minutes before the end of the bidding, would you say, well, the buyer could have looked it up and known that that was a lie, that was false? Does that seem right to you?
Yes, Your Honor, because it goes to the issue of special facts and whether Emeris can be charged with a fraud despite its disclaimers. The appellate division departments are all motion to dismiss cases. They're not summary judgment cases because New York puts weight behind these disclaimers and puts weight behind a sophisticated buyer's obligation to perform due diligence, even if they decide to bid at the last second and are susceptible to a false statement, even based, the reason that we're assuming the statement is false is because this is a motion to dismiss. So I would just ask the court to place this case in context of other decisions on motions to dismiss that dismiss fraud claims, going back to the 1959 Court of Appeals Denman Realty case, which says literally If these disclaimers aren't good enough, then no disclaimers are good enough.
All right, we understand. Thank you.
Thank you, Your Honor.
Mr. Moskowitz?
Thank you, Your Honors. May it please the court, I represent CBRE Inc. and its broker, William Vonderfecht. And certainly I don't want to belabor anything that's been said by Mr. Scher, but I would like to highlight a couple of things. The question was raised concerning this drawing, which has been described, frankly, incredibly by Brookstone as an architectural or construction drawing. It is not, and it's clear that it's not. It is a simple conceptual drawing which clearly warns those who were viewing it that it was for inspirational purposes, and certainly would not on its face relieve Brookstone of the obligation to do its own diligence as recognized by the legion of cases that we've cited to the court. And I would like to point out that many of the cases that we've cited to the court are closely analogous to this one, dealing with buyers who claim to have been surprised after their purchase that the zoning in place would not permit them to develop a property in the way that they claim to have hoped. So the cases are clear. This matter is ripe, was ripe for dismissal, and I respectfully submit is ripe now for dismissal based upon facts that are uncontroverted. The Brookstone admitted in the purchase agreement that it was a sophisticated purchaser, that it was an experienced developer who was capable of assessing the merits and the risks of this transaction. And Your Honors, I submit that what could be more basic to commercial real estate development than verifying the zoning, to verifying whether or not one would be permitted to develop the properties in the way that they now suggest. And it's uncontested that Brookstone never lifted a finger to do that. And further highlighted—
never lifted a finger in the 2 hours that it had before the bids closed.
Your Honor, I'm not, well, before the bids closed, but there was nothing that stopped them from doing some investigation. They chose not to visit the property, but they acknowledged in the purchase agreement, Your Honor, that they had every opportunity to complete all of the diligence that they deemed necessary and appropriate. And again, what could be more basic than determining what the zoning was before you buy a property?
Yeah, well, I guess the argument is that this idea that you can make additional units on here and still be within compliance with the zoning laws, that wasn't broached until 2 hours before the bidding ended. They had no reason to investigate that because it wasn't communicated to them. But I guess, so that's their argument.
Yeah, I appreciate that. And as Mr. Sheriff said, that is their best argument, but it doesn't make sense and it doesn't hold water, Your Honor, when we're talking about a justifiable reliance standard. Even if you would, and I'm suggesting, suspend disbelief and credit this conceptual drawing as some type of implicit representation, which it is not, and representations were expressly disclaimed, you still come to the issue of whether or not they could have justifiably relied upon that. Could someone spending $16 million to develop a property commercially, and a sophisticated buyer, an experienced developer, could one justifiably rely on that conceptual drawing without lifting a finger to determine the zoning, as they did the very next day, Your Honors, to show how simple a matter that was? The very next day, they verified what was always verifiable, and that was the zoning for this particular property. And now, when they apparently had buyer's remorse or changed their mind or whatever the case may be, based upon the overwhelming authorities that we've cited to the court, Brookstone can't lay off their buyer's remorse on either the seller or its agent.
I'm not sure buyer's remorse. I think they were angry that they got lied to, or there was a misrepresentation. But we understand your point, and we've read the briefs. Anything further?
No, thank you, Your Honor.
Right. Mr. Robu?
Good afternoon, Your Honors. May it please the court. My name is Rachel Rubel of Jacobowitz, Newman, and Tversky LLP on behalf of the respondent Brookstone 8 LLC. I'll focus my remarks briefly on what opposing counsel have both mentioned. To begin with, Mr. Scherer stated that the brokers were acting on its own. I think it's clear from the record, I think it's clear from the briefs that CBRE and Mr. Vanderwater were acting as representatives on behalf of the plaintiff appellants here. I don't think there's any dispute at this point that the allegations that were being made, the emails that were being sent were on behalf of the plaintiff Emeris. As it relates to justifiable reliance, first and foremost, those are, as your honors have previously mentioned, those are improper on motions to dismiss. They are more suitable on summary judgment grounds, but just in terms of the reliance that my clients had on the plaintiff and the defendants in this action, as your honors are aware, there was only 2 hours here when Mr. Vanderwater called and then subsequently followed up with that writing, and the email stated, here's the floor plan conversions and the current unit mix is below. That's in the record, that is clearly referenced throughout all of the briefs. While I understand that there may be some small clause regarding these conceptual plans, the fact remains that Mr. Vanderwater brought up this new idea to my clients, something that made them truly believe in that short period of time that these plans, could be used. Now, while
and you would argue that he clearly thought your clients would rely on it because he wouldn't have sent it in the first place if he didn't.
Correct. Why would they be sent in the midst of the bidding process when there was only a short time left? Why would they be sent to my client at all if they couldn't be used?
What about the disclaimer? Your client signed the agreement. The agreement included the disclaimer that I mean, you have the language in front of you, as do I. I'm not going to read it, but why doesn't that bar the claim here?
Well, as the court in the initial decision held, it was more of a general disclaimer. It doesn't specifically address any issues, including zoning issues, which is the heart of this fraud allegation. And considering there was no specific disclaimers, it's hard for any person who is doing their due diligence or who is signing these agreements to rely on a special clause like this, especially in a case like this where there were these written representations that came after this, that came in the midst of this bidding process. It became confusing, and I think even a sophisticated buyer can be, misled by certain information. At the same time, Mr. Vanderwater himself was a professional. He should have known, as your honor just stated, he should have known that my client would have reasonably relied on the email that was being sent to him during the bidding process.
All right. Thank you, counsel.
Thank
We
you.
appreciate the argument. We'll call case 667, Manufacturers and Traders Trust Company versus Vanderwater and Vanderwater LLP. Also, 668 goes with it.
May it please the court, Tara Shortino on behalf of Jamestown, the town law firm.
All right, if you want to make sure opposing counsel is here, and she is, so.
My apologies.
Thank you.
Just a couple of brief points. The lower court should have dismissed the third party complaint as it is conclusory and had no factual detail. The only things pled are a waiver of a child, failure to appeal, and conducting dilatory discovery. There's no factual context to give any notion to how my client's strategic choices in pursuing the representation as he did was unreasonable. Therefore, the lower court should have dismissed the third party complaint.
Counselor, on this issue, just so I understand the record, the facts here, as the parties laid out, seems to be that Vanderwater was counsel one. They prevailed in front of Circuits Court in a decision I found online. And that went up and was decided 4 years later adversely to Vanderwater's client, M&T. And in fact, if it was flipped to the extent of liability was granted by the second department in favor of the opposition.
That is correct, Your
So
Honor.
far, so good.
That is correct, Your Honor.
But it was at that point, essentially, that town was substituted in place of Vanderwater.
That is correct, to take over the damages aspect of the case.
So anything having to do with the damages aspect vis-a-vis M&P and the award against them was handled by your client.
That is correct.
And if I understand the third party complaint, they're essentially saying, well, wait a second. You also breached a duty to M&T by not doing these things, one of which was, I think, stipulating to facts rather than requiring a full trial. Another was not appealing to two adverse decisions by the surrogate awarding money. I forget the third one has something to do with discovery. But that's, do I have the layout of the facts correct? I just want to make sure that I do.
Excuse me, that is correct. The first one was proceeding on submission rather than seeking a trial.
And in the event, assuming argument that the court was not to agree with your argument on the third party complaint, it would make sense that your client would need to be disqualified because they're going to, I think the rule 3.7 talks about, and I don't mean to get you off your first argument. If you need to go back to it, just do it. But here's what's, and I'm tying the two together.
Sure.
Forgive me for going on. But the only test, according to Simons, on professional responsibility, the only test in the text of 3.7a is whether the advocate is likely to be a witness and on a significant issue of fact. The town law firm would certainly be a witness with respect to what was done and the decisions that were made in the damages portion of the trial. Do you agree?
As to the case against them, however, I think how it is that is town going to be called as a necessary witness in the trial against Vanderwater? And is he going to testify adversely to M&T?
That rule about adversity, by the way, has kind of gone by the wayside 14, 15 years ago when we went from the DRs to the new modern rules or the code. So if you look at Simons, and it was interesting, neither party cited Simons on professionals. He's got a great discussion of the changes to the rule that happened 15 years ago. So the necessity actually is still not part of the rule, although the courts still use it as a vestige of the old one. But it talks about provide, just quoted it, whether the advocate is likely to be a witness on a significant issue of fact. So I understand how the town law firm wouldn't necessarily be a fact witness in the case against Vanderwater, but certainly they're going to be one if we affirm denial of the motion to dismiss the third party complaint. There's certainly going to be a witness vis-a-vis the third party complaint.
I would agree that he'd necessarily have to be, since addressing the work that he performed. Excuse me, apologize.
I've got the same issue going on, so don't worry about it.
If they're, is it your point that if they're severed, then that problem is alleviated?
That is my point, Your Honor.
But why wouldn't seem to make sense to sever them? The third party contribution claim is directly related to the first party claim of malpractice. And it would seem that the jury, first of all, it wouldn't make sense for judicial economy to have two separate trials, but these issues are all interrelated to like causation, and if there's no severance, you agree there's a problem with the disqualification.
I still disagree, and I still don't think that the Vanderwater defendants have shown that. Apologize.
Yeah, that's okay. You can get some water for that.
I don't think the Vanderwater defendants have shown more than a conclusory conflict, that they haven't elaborated on what the conflict is. Testimony.
If there's no severance, town would be testifying as a witness at trial, right?
Correct.
And he's a lawyer for one of the parties. So he would, and he has a financial incentive. I mean, he could lose money here. There could be money coming out of his pocket. And he's representing another client. Could be a witness. Well, almost certainly would be a witness. Does he have somebody else from his firm direct him? I mean, I don't know. It seems like there's two issues. Is one, he's a witness, two, he's a party. It just seems like just too much. And we have the trial judge disqualified him. So there's an abuse of discretion there. We tend to defer a little bit. It just seems like a big ask for us to overturn that exercise of discretion, given these facts.
Again, I respectfully disagree, and quite honestly, I don't even think we get to this issue if the third party complaint is
True,
dismissed.
that's true, yeah.
Agreed, and that's where I started, Counselor, is that it seems like some of the allegations are, for example, by the Vanderwater firm and a third-party complaint, as I understand the record, that allegedly your client did not get the consent of M&T, or certainly wasn't informed consent to say, let's not do a trial, let's do stipulated facts. Oh, and by the way, let's not even appeal the decisions awarding damages. So if that complaint survives, doesn't somebody from the town law firm have to testify in the third-party action? And aren't those facts necessarily overlapping to the claim against Vanderwater? At a minimum, as the Justice presiding indicated, with respect to causation of harm. Imagine an accident. In fact, it was 1 year ago, I think I sat on, where there was an exacerbation of an injury. The plaintiff was in the driver's seat. There were two different products liability things with Letco and there were two different manufacturers. And the allegation was the second malfunction exacerbated the plaintiff's injuries from the first malfunction of the product. Similarly here, when you have an exacerbation of the injury, hey, you didn't appeal, you might have lessened the amount. You didn't go to trial, you might have gotten a different, lesser result. So I'm having trouble why this is not severed. I'm not sure that that would be a proper use of discretion to sever when there's common facts and common issues. I've teed it up for you, go at it.
Sure, if I can go back to the beginning. So there is nothing actually in the third party complaint. So what I raised in my papers was they didn't raise that, for instance, like the surrogate's court erred somehow in making its determination on the surcharge, which would have led to a relevant appeal, perhaps in that case, or why submission was not appropriate under the circumstances, what was not produced at that time to the court. Because, by the way, it would have been before the submission would have been before the same judge if it would have been a bench trial. If that makes sense, because of the nature of the proceeding before.
But that explanation is going to require testimony from the town law firm that is why we chose to do the stipulation of facts.
And I understand that. However, those facts are not pled in the complaint. And that's why I'm advocating that it should have been dismissed in any event.
Right, well, it seems like the question is whether we've got a lot of these cases. Is it 3211 or does it delve into 3212? And Justice Kern seems to be suggesting is that we need to hear the reasons for the strategy. And to do that, it's 3212. And unless what you're saying is that under no circumstances can giving up a trial in lieu of paper submissions, that's always going to be a strategic decision and it could never be malpractice. Similarly, not filing a notice of appeal and an adverse ruling is always strategic and never be the subject of malpractice. Is that what you're saying?
That's not what I'm saying.
Okay.
But what I am saying is that the third party complaint is actually lacking the factual context for why the act of not appealing was somehow negligent, or why the act of proceeding on submission and presumably offering the same proof that would have been offered at the time of trial.
So, yeah, it's just a question of, is that something that can be demanded in bill of particulars to get into discovery? Or do you got to put it all out there? We'll take a close look at that.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Maxine Nicholas with Gordon Reese Scully Mazzicani on behalf of the respondents. I'm not going to kind of belabor the points that you raised with appellant counsel, but and more rely on our briefs. But I think, we all know that under a motion to dismiss, the pleading standard is liberal and all inferences are most favorable in light of the non-moving party. And we would submit that the third party complaint specifically and sufficiently delineates a claim for contribution. It states that, the town law firm had a duty to M&T, and we set forth our belief as to what the breach of that duty was, and that there were damages, and that those damages were aggravated or contributed to the surcharge.
Counsel, we don't have a written decision, but was there any discussion below as to severance and understanding between the parties or anything like that these issues are going to be severed?
No, Judge, there was no discussion at all with respect to that. And that's why I kind of raised it in our opposition, because appellant's counsel has made the argument that there's no danger that Mr. Town will testify in this matter. But like your honors have said, the fact of the matter is this is likely to all be tried together. There would really be no grounds for there to be a severance in this type of case when everything is going to damages, right? M&T is seeking damages for my client for its alleged malpractice, but Town handled the damages phase of this litigation, and it's our contention that how he handled it deviated from the standard of care and contributed to the ultimate surcharge. And that's what's set forth in the third-party complaint. And we set forth why we believe there was a deviation from that standard. And while the appellants may disagree, we're entitled to discovery on those issues. And
Counselor, let me interrupt. Did you happen to come across in your research a case called Stark versus Greenberg, Dauber, and Epstein, 219 AD 2nd 571? It's from the First Department in 95. And here there was apparently some dilatory conduct in bringing the third-party complaint. It was in both, it's the same context as I understand it, in a legal malpractice case. And the court says, and here you filed your third-party complaint right away, right?
Correct.
There was a delay. So I think that, but the First Department found that the severance was a abuse of discretion because it could, that dilatory conduct should not outweigh the consideration that the main action of the third-party action involved common issues of law and fact. I mean, we're not even to the severance point. No one's granted severance. No one's even applied for severance. But your point is, I understand it, is exercising discretion to grant severance down the road, you would suggest is highly unlikely.
Yes, absolutely, Your Honor. And I think, and that goes to the point of, Mr. Town being, an advocate and a witness under 3.7, but I think also under 1.7, the appearance of a conflict. Putting aside 3.7, 1.7 says that attorneys must, engage in a manner to ensure that there is no appearance of a conflict. And if you have Mr. Town as the advocate for the plaintiffs here, and then he's also a named third-party defendant in which we are alleging that he damaged his own client, I can't see a situation how that's not an appearance of a conflict. And so I think, the lower court properly disqualified Mr. Town under 1.7 and 3.7.
Of course, we have no basis to know what it was Supreme Court exercised its discretion on, because to my understanding, the record is devoid of any writing, correct, explaining the court's discretion.
That is correct, Your Honor.
All right, thank you, Ms. Nichols.
Thank you.
Case 671 is next for argument. It's Stephen R. Brongo versus Town of Greece. Good morning, counselors.
Good morning. Alan Bose, Maxwell Murphy for the plaintiff's appellants. May it please the court. We submit that Justice Sinolfo improperly dismissed the plaintiff's complaint when all of the evidence is viewed in the manner it must be on a summary judgment motion on the town's motion. There are questions of fact requiring trial by a jury. And I think one of the best ways to look at all the various issues raised is to look at the text messages that are included in the record and in the defendant's brief. They're in the defendant's brief, pages 41 to 42, and elsewhere. Mr. Brongo learns from his employer that he's going to be operating this water truck. And that's on Friday. The accident happens on Monday. And one of the texts that Mr. Brongo sends to Mr. Rickard, his employer, shortly before the incident, the plaintiff states, actually on Friday when I talked to Craig Smith, he said I would have everything I would need for the truck. And so there we've got him, Mr. Brongo, communicating with Mr. Smith, saying, look, this has not been right in the past. It needs to be right this time. It's a problem. Make sure I've got what I need. Make sure the truck has what it needs. Mr. Brongo gets to the town garage. The hose is inadequate. It won't attach to the truck. And he texts Mr. Rickard, once again, the water truck was not equipped with the proper fittings and hoses that I need. Well, I think that does a couple of things. First of all, it shows that Mr. Rickard now has noticed that there's a problem, which we know from Rizzuto and the other cases. That's enough to bind in the town under their non-delegable duty under labor law section 241(6). It also addresses the argument by the defendant that the hose isn't part of the truck. Mr. Brongo himself refers to it as part of the truck. The water truck is not equipped with the proper fittings and hoses that I need. Mr. Brongo, who works with this equipment, sees it as part of the truck. Further support for the fact that the hose is part of
Mr. Voss, just so I understand, you're saying that wasn't the hose, forgive me if I got the facts wrong. Wasn't the hose owned by the town?
We don't really know who owned the hose. There is no definitive proof as to who owned the hose. It was present on the town's property attached to the town's hydrant at the time of the incident when the plaintiff arrived, but we don't know.
So for purposes of negligence or common law 200, just to kind of keep the theme, if it's not the town's hose, you have no defective condition.
Oh, I would disagree, Your Honor.
I may have messed it up. Tell me why. I know I'm skipping ahead, but then we'll come back.
Okay. First of all, I think everyone agrees, I may not agree, that the hose was defective. It couldn't be coupled to the truck, requiring the plaintiff to get up on the truck. The plaintiff testified that in years past, he'd worked on these jobs in the past and used this hydrant and used, if not this hose, a similarly defective hose. He complained to Mr. Cabot, the town foreman, about that.
I'm focused on who owns the hose. Because if you're arguing under 200 that it's a defective condition as opposed to means and method, then, and if the town doesn't own the hose, they're not liable for the premises liability claim effective that you have for the hose. So that's why I thought to interject on your first argument when you said it's unclear who owns the hose. And so I'm trying to translate the two. So if your argument is we don't know who owns the hose, your 200 based on defective condition is probably out the window.
Well, Your Honor, I think a jury could reasonably infer that the town owns the hose. We don't have any testimony that it doesn't. All right. So it's there at the town's property, attached to the town's hydrant. The plaintiff says, I think it's the same hose I've used before. So I think it's a reasonable inference for a jury to make that it's the town's hose.
You see where this is going, that if it's the town's hose, it's probably not part of the truck for purposes of being power equipment.
No, I wouldn't agree with that, Your Honor, because the mere fact that the hose might be owned by the town, it still is an appurtenance of the truck. It's something that works with the truck. Whether the town owned the hose or anybody else owned the hose, as I just read, Mr. Brongo refers to it as part of the truck. And the other thing is that Mr. Cabot, the town foreman, testified about using different pieces of equipment. And he said, the hose that you use varies by the equipment that you use. The attachment to the hydrant doesn't vary. The attachment to the equipment or the truck varies, thus leading to, again, an inference. I would suggest that means it's part of the truck. If you need a hose to fit the truck rather than the hydrant, it's part of the truck. I hope that answers your question.
I'm thinking about
All right. I'll continue. We can come back to that if we need to. So Mr. Brongo then further text to Mr. Rickard, there are no hoses, no fittings, so I'll have to climb on top of the truck. Mr. Rickard in response, sorry, I thought I was specific enough with Craig to make sure this would be set up properly. Mr. Rickard does not say, do not climb up on the truck. He does not say, wait for Mr. Smith. He doesn't say anything of the sort. What he says was, I'm making calls now to get you a proper setup. He doesn't say wait. He doesn't say don't proceed. Now, I think it's important. We've got the plaintiff saying he talked to Mr. Smith Friday. He arrives at the property Monday. Mr. Smith has not done what the plaintiff on Friday asked him to do. He then calls Mr. Rickard. Mr. Smith testified, number one, Mr. Rickard never called me to talk to me about a hose on Monday. And number two, it's not my job anyway to give Mr. Brongo the hose that he needs. So if it's not set up properly in the first place, and the person who Mr. Rickard expects is going to bring the hose says he's got no duty to do that, and nobody ever talked to him about doing that, what reasonable expectation would the plaintiff have that any proper hose was going to arrive? So he had to proceed in the way that he did. So I think we've got that as well. I think the inference is also plain from the colloquy between Mr. Rickard and Mr. Brongo that Mr. Rickard expects him to do it the way he had to do it. The milling machine needs water. The job can't proceed without it. He's got to go, and he's got to go get it. So the next point I think that is important, and one of the arguments that the town made in its brief was that the plaintiff could have and should have returned to the location in Rochester where he previously got watered. We raised the argument in our brief that that's brought up for the first time on appeal. We had no chance then to marshal any evidence against it in the court below, so the court shouldn't consider it. To the extent the court does, I think that's essentially an admission by the town that the plaintiff's actions couldn't have been the sole proximate cause of his injuries. As Gallagher from the Court of Appeals tells us, to show sole proximate cause, you have to show there was a device available on the site, even if not in the direct vicinity of where the accident happened. The plaintiff chose not to use it for no good reason, and he was injured as a result. Well, if the plaintiff has to leave Greece to go to Rochester to use a proper hose, then there's no proper device on site, and the first leg of Gallagher fails. So it was reasonable for the plaintiff to do what he had to do. He wasn't instructed by his employer not to do it. He had no reason to expect that any proper hose was going to arrive. And the only thing he possibly could do was leave the site, which isn't required of him to do. The town raised questions about access to the hydrant. There's testimony that Mr. Cabot knew that the plaintiff was using the hydrant. It had been the previous practice to use the hydrant. Mr. Rosigliano, who was employed by Sunshine Concrete, a defendant who was ultimately dismissed, testified that he himself told the plaintiff to use that hydrant. And in the texts with Mr. Rickard that we were just talking about, nowhere does Mr. Rickard say, hey, why are you using that hydrant? You're not supposed to use that. That doesn't come up. So again, the inference is it's the proper hydrant.
Time's running short, so if you want to wrap up.
Yeah, I guess the only other thing is, between all of the testimony we've cited and the expert testimony we submitted, the affidavit of our expert who says this is a violation and of Rule 9.2A and therefore a violation of Section 241.6, the town was in violation of the statute.
Thank you, Councilman.
Good afternoon. Craig Chartier on behalf of the town of Greece. May it please the court. I guess first I'd like to address Justice Curran's questions about the hose and the ownership of the hose. There are a set of facts that were undisputed in the motion papers below. If we look at the record, I think it's 1160, where the town of Greece has a statement of undisputed facts. Plaintiff responds to that at the record at around page 1314. There's multiple pages to each of those documents. I think 1314 is the correct page where things are admitted. And one of the admissions is that all of the town's hoses have correct couplings at both ends. Town doesn't have any cut hoses. So that's an admission by the appellant as part of the motion. It's undisputed. So I don't think we can come up here and
undisputed. I'm not exactly
that the town does not own this hose, because they've admitted that all the town's hoses have the proper couplings on both ends. They don't have cut hoses. There was testimony by, excuse me, both Brian Cabot, who's the general foreman, and Mr. Vanderwater, who is the gentleman driving by at DPW when he sees Mr. Brongo fly over the truck and land on the ground.
So you know how we follow the courts here, a strict burden shifting analysis. Did you prove in your motion papers as a matter of law that you didn't own the hose?
I would say that there would be probably a question as to who owns the hose, but there's an admission that all the hoses owned by the town of Greece have couplings on both ends. So to be able to say that the town owns the hose, we can't do that.
But how do we get to that admission when all we look at is your papers? We don't even peek theoretically at the answering papers. So what's in your motion papers on that issue? And maybe I'm off on a tangent if I.
No, I don't think you are, but I think then we get back to the testimony of the general foreman and the other person from the town of Greece, the other employee that says, yes, we have these hoses. They all have the proper couplings. Never seen one with an end cut off. We don't use anything like that here. We always have the proper couplings for our hoses.
And that's in your motion papers?
That's correct.
Okay.
Whose
testimony was that again? So
that is Brian Cabot, who is the general foreman for the construction project, and Mr. Vanderwater, who is the town of Greece employee that's driving by and just happens to see the accident occur.
Okay.
Both of those gentlemen testified to that. The other point I wanted to make is in regard to the hose being attached to the hydrant as opposed to the truck. This is the case both at the town DPW and where the appellant loads up his truck that morning. Less than 15 minutes away, he's at a villager site, Colfax, near Mount Reed. Less than 15 minutes from the milling site. He goes there that morning, uses a villager hose with the proper couplings, fills his truck up the right way, and leaves the hose behind, attached to the hydrant. Not to the truck, it's attached to the hydrant. So I think if we look at a fair reading of the record, I think it supports the lower court's decision here that the appellant was the sole proximate cause of his injuries. There's no evidence at all that shows he was required to use that torn hose at the town. There's no evidence in the record that shows he should have been using that hydrant. In fact, his supervisors couldn't say he was authorized. There was a Monroe County Water Authority permit that was issued to Sunshine Concrete, not to Villager. Sunshine Concrete testified that the appellant was not authorized. That is an incorrect statement that Mr. I think it's Rosingo. I don't know how to spell his, I don't know how to pronounce his last name, but it was Jimmy Concrete. His name was on the permit. He testified that at one point earlier in that construction season, in June or July, someone from Villager used that hydrant. This accident occurred in September. There's no proof that there is any authorization to use that. And in fact, that morning, again, it's undisputed. The morning of the accident, Villager, who's required to supply the water for the truck, it's not the town that's supplying the water, it's Villager. They supply the water at an offsite location away from the milling site with all the proper equipment. And it's in the lower court's decision, not raised in the first time by our papers on appeal, the lower court's decision, record at page 5 in the factual history. Again, lower court's decision, record at page 8 in the findings and conclusions of law, that the appellant knew that the hose with the proper couplings was located less than 15 minutes away. And one of the things he didn't do, in addition to not waiting for his supervisor to show up with the proper equipment, who he says in those text messages, the supervisor tells him, hang on, I'm getting you the proper setup. He testifies, that supervisor testifies, I thought I was clear enough that he should just hang out and wait. He doesn't do that. He doesn't go back to the location by Colfax where he knows he has the proper equipment. He decides on his own, I'm going to go up here and try to rig this thing and fill it this way, after acknowledging in those text messages that this is not smart.
You're still on the sole proximate cause point, right?
Yes.
Can I just take you briefly for my purposes to the section 200 and common law claim?
Yes.
This is sort of where I was coming from with the ownership of the hose.
Yes.
As I read your papers, and correct me if I'm wrong, you moved solely on the basis of the means and method.
That's
You
correct.
did not move on the basis of defective condition. There is some reference in the bill of particulars and in the motion papers that the plaintiff is also relying on the defective condition of the hose. Do you agree with all that I'm reading the record correctly? And if I'm not, let me know. I'm okay with that.
I think there could be an inference there, yes. But I also think that your point earlier about if it's not the town's hose, then how can this possibly be? And the other problem with the 200 argument is you've got to have supervision of that hydrant, of the actual work.
But not for defective condition. That
Well,
has to do with means and method, correct?
Yes, means and method. I'm sorry, yes.
No, and you made that point on supervisor control.
Yes.
But the question is whether or not defective condition survives, if at all. I don't think you even moved on that basis, so we got to look at, so if we look at it and say, okay, the town doesn't own the hose, if you showed that as a matter of law, then we might not, I'm not saying this is the case, but we might not have to look at defective condition.
Understood.
I'm not sure I'm putting apples to apples together, but I'm doing my best.
Understood. No, I think most of the point I think that I wanted to make today was on the sole proximate cause argument. Because I think that if the judge below is correct, he correctly dismissed the 241-6 claims, no matter what regulation we're citing to. And we don't even have to get to the idea of, was this motion timely? Did there need to be special circumstances? Doesn't matter because the appellant was the sole proximate cause of these injuries. And I mean, again, I think if we look at all the circumstances leading up to what he's done here, again, it's pretty clear the appellant wasn't forced, he wasn't directed, he wasn't required to act this way. His supervisor didn't tell him, go get the job done. He said, hang on, I'm getting you the equipment.
Council, I think we understand
Okay.
that. point.
Thank you, Judge.
Thank you very much. 672 is Boland's Excavating and Topsoil versus Bradford Central School District, 672. Good morning, welcome.
Good morning. Ryan McCarthy with Ferrara Forenza on behalf of the Bradford Central School District, who's the third-party plaintiff and appellant in this matter. Before I start, the procedural posture and the contractual relationships in this case are not straightforward or simple, but the question to this court is, what is the proper standard for a pre-answer motion to dismiss under 3211? The district submits that the trial court order should be reversed because it used extrinsic evidence to make factual determinations about the underlying case without any.
This will be the theme of today. You've been paying attention, you'll see this is
Yes, and
first time this issue's come up today.
Yes, and the specific factual determinations on there were made without any discovery in the matter, and some of it would be unavailable to the school district in this case because some of the evidence that could have been disclosed through discovery would be communications between the plaintiff in the underlying case, Boland Excavating, a prime contractor, and the third-party defendant, Schuler-Haas. Unfortunately, Schuler-Haas was wearing multiple hats. They're a prime contractor and a subcontractor on the project. And the point of our lawsuit is we don't know whether the work done that caused the damages was done under their prime contract or under their subcontract with Boland. According to this court in a Bukovetsky decision from 2019, a defense based on documentary evidence must be unattended by the danger of misconception. Now, Schuler-Haas submitted emails along with portions of the contract and their subcontract that show that.
Counsel, I know you'll get to the email and I appreciate it and I want to hear the argument, but before we even get to the emails, looking at the prime contract on page 42, there's reference to electrical power to the concession stand and scoreboard. And then it says power. I'm not sure what that means, but in the subcontract, there's a lot of more detailed descriptions of provide and install disconnects for the scoreboard, provide and install pipe and wire to disconnects and to those scoreboards, provide and install pipe and wire for the future concession stand, or spare conduits for the future concession stand, et cetera. It seems that we have that overlap. Is that enough in and of itself that we have the overlap between the two contracts?
I think it is to avoid certainly a pre-answer motion to dismiss. I mean, the point is that the work was done for the electrical work on the irrigation system that ultimately failed. And it was done by Schuler-Haas. I don't think there's any dispute about that. It's whether they did it under a change order under their subcontract, they did it under something else. We just don't know. And even the court was unclear on whether or not it was under the Boland prime contract. They wrote in their decision, which again, we strongly disagree with the basis in this case, that there wasn't enough facts for us to prove that it was under their contract, which again, wasn't the point raised in the motion, yet somehow was the basis for the decision to dismiss our third party action against Schuler-Haas. But yes, I think the overlap and the extensive electrical work done by Schuler-Haas is, I think, dispositive of the motion that requires dismissal. But one more point on that too is that I think the motion brought by Schuler-Haas and the court below make the assumption that we're absolutely clear on what the actual electrical failure was that caused the sod to fail anyways. I'm not an electrician. I read about the overvoltage thing in the emails and I don't understand it. And I don't think the court in that position was in a spot to say, yes, that was the cause and it was done under this portion of this scope of work of this contract. It's simply too early to tell any of those things. And so I think this court should avoid making that same assumption that we know exactly why it failed and who did the work that failed that caused the sprinkler to fail. The other point that we mentioned about the emails was, well, the contract itself would probably be considered documentary evidence under 3211A1, although it does have the danger of misconception because the emails state that portions of the initial RFP were missing and somehow this wasn't included in an initial RFP. So I think that danger of misconception exists, which again, this court held in 2019 precludes its use of documentary evidence under a 3211A1 motion. The emails are a whole different issue and I think fall well below the standard that the contract arguably could reach. The emails are full of hearsay and half of them take place after the sod failed when people were in panic mode to fix the sod. Again, the court below mentioned that someone from the district was out there hand watering the grass that had died as somehow an implication that it was the district's fault. Again, we strongly reject that and I don't think that is an argument in this motion. But that's the type of context these emails are brought in. Not a long, extensive analysis of these 1,000-page documents that include various specifications, manuals on how the work to be done. So those emails, I do not think have that conclusive evidence for what the interpretation of those scopes of work were, even if we can assume we know that the overvoltage issue was the sole cause of the irrigation system to fail.
I think we got it, counsel. If there's anything you want to wrap up with.
One last point is, and it was raised in the reply brief, was the school district did ask for additional discovery on this, and that issue is preserved for this appeal and was raised at the motion level court. Thank you.
Thank you very much. Mr. Stryker.
Thank you. I'm here for Mr. Stryker. My name is Michael Higgins, at Ernst & Young trustee. First, to your point, Justice Nowak, the notation on page 42, if you read what page 42 is, those are payment milestones. They're not specifications of what the work is to be done. The work that's to be done is in the specifications and plans that are appended to the contract. And the district agrees that the work is not included in this contract. They say in their reply brief, the district does not deny that the original Schuler-Haas contract scope of work omitted the electrical work for the automatic irrigation system and the athletic fields. So they're admitting that none of the work on the athletic fields or irrigation system is in the contract between the district and Schuler-Haas. And their claim against us is for breach of contract. So if the work, the allegedly defective work, is not in the contract, they can't sue us for breach of contract. We're not in privity with them. And I think that the contract alone proves that. You don't need to reach the emails. The emails are there really for context. The second point about that my opponent made here today about the ambiguity in the RFP, that's in the emails, and that's a description of ambiguity in the subcontract between Boland and Schuler-Haas. The idea that the district doesn't know which work they assigned in which contract is incredible. This is a very common situation where you have two prime contracts, they split up the work, and then Schuler-Haas worked as a subcontractor under Boland. Pointing to the question of what is the cause of the breach? They allege the causes in their third-party complaint against us, and what they allege is that we failed to connect and install the materials improperly with respect to the irrigation system and the athletic fields. Well, that work they're admitting is not in the prime contract between Schuler-Haas and the district. It's somewhere else. We don't need to see that other contract. We just have to know it's not in the contract that's at issue here.
But is that basing the argument that the failure, the error that occurred is within the power directly to the irrigation system itself, as opposed to some kind of a voltage issue backed by the school further back that was done pursuant perhaps to the prime contract? But we don't know what the electrical failure is.
We don't know what the electrical failure is, but we know what they alleged, and they alleged that the defect is with the work that was done on the athletic field and the irrigation system, not the other work.
They also allege it was due to a failure of the electrical equipment provided and installed by Schuler pursuant to its contract on the project with the district. This is page 19 of the record.
Yes, I think if you read the whole, the full allegations, it's clear that they're alleging that the error is in the work that happened on the irrigation system. I mean, the irrigation system is what failed. And they're really pivoting after suing us to invent a new cause or a new claim. So I think you can reach that there's no privity, that the work that's alleged to be defective is not included in the contract, and you show that through the contract. You don't have to reach the emails.
Thank you, counsel.
Thank you.
Last case on for arguments today is 673 First National Credit Incorporated versus Christie's Cleaning Incorporated.
Good afternoon, Your Honors. Alex Neror for the plaintiff appellant. May it please the court. Plaintiff is appealing the lower court's order granting the defendant's pre-answer motion to dismiss. On this appeal, the plaintiff contends that the lower court erred in granting the defendant's motion by misinterpreting the evidence that was presented both in purpose and in substance. In this case, on the motion, the defendants did not submit any evidence other than an affidavit from the defendant, Christie Johnson. All of the evidence that was before the trial court was offered by the plaintiff in opposition to the motion. That evidence consisted of phone recordings of the parties and copies of invoices that were issued by the plaintiff and paid by the defendants.
Can I ask you this question? What happens if the audio recordings that your client submitted in opposition to the motion negate the elements of your complaint with respect to what the parties agreed to as far as partnership? There's allegations as to 50-50 split. What if the audio conversations of these surreptitiously recorded phone conversations or messages are contrary to the allegations in the complaint? Can we consider those in a 3211, or is that more a summary judgment?
I would say it goes to summary judgment more so. It's an issue of fact. But I would say that this was the misinterpretation by the lower court, that these audio recordings were the oral contract itself. The lower court took these audio recordings, which really were just a snapshot of the parties' relationship and dialogue conversations about their agreement over a period of years. But the court interpreted that as supposedly dispositive proof that the plaintiff was trying to prove the contract through the recordings.
Can you point where in the complaint it alleges that they had an agreement for your client to be a permanent owner, part owner, such for forever and ever, such that when she sold it, he gets half? I get that there was a lot of allegations here on the 50-50 split for his compensation, and he did get 50-50, right? He did get paid pursuant to that agreement. The dispute is when she wants to sell it, he believes he's entitled to half. Where in the complaint specifically does it allege that she ever agreed that you have half of my business Where's that?
Correct, Your Honor. I believe it's stated clearly in one of the statements verbatim from the recordings that the defendant, Christie Johnson, stated that she understands totally that they even it up and then they split it when they sell it.
So, but where, what paragraph of the complaint is this alleged? You know, I know I'm putting you on the spot and you may not have it in front of you. I just was curious. Because that's the allegation, is you haven't stated, the claim is you haven't stated a cause of action and you don't have one, and more particularly, I think is what the judge said.
Following up with the justice presiding's question, I'm looking at page 17, paragraph 26. I think maybe that's the closest you get. Where you reference the 50-50 split.
So I think this goes to the cross motion to amend the complaint as well. In the record on page 71, the statement that I'm referring to is found at paragraph 57, which admittedly, that's why we made the cross motion to add further context of what this 50-50 split was comprised of.
Okay, but in the original complaint, just as the current reference, page 17, that there was an agreement here that your client would get 50% of the net sale proceeds. That's different than being half owner, right?
Well,
this was his compensation. The whole idea is how's he going to get paid? He was a consultant. He did it for free for a few months in August to October 2020. And then how are we going to get paid? And he had this pay program where he brought people in that didn't work. And then he wanted equity, or he wanted some management control. And so we're curious as to where's the allegation that she agreed that you would get half of the business forever and ever and ever.
So
that, and that she could never fire you, by the way, that no matter what your performance level could be, she can never get rid of you.
Well, I think that speaks to the context of what the arrangement was. When the plaintiff came in to help out with this company, the company was in a desperate spot. It was failing. It did not have the means to pay him. Essentially, his compensation was tied up in the performance of the company. She was placing her, trust in the plaintiff, Mr. Lajudis, to turn this company around. In doing so, this was the agreement that they struck. I'll point to page 71 of the record. Again, I realize that this is the amended complaint, the proposed amended complaint, but it does speak to what they were trying to do, that they were going to even it up, split the difference. And again, this also, I want to kind of digress here back to my main point that this was the misinterpretation of the lower court, that these recordings are definitive proof of a deal when that's not what they were offered for.
But that language that you cited, that came right out of the January 30th, 2021 recording.
The language that I cited, yes, correct.
It did. So we have the rest of the recording. It's 30 minutes and 29 seconds. And then we have another 60 some minutes after that of additional recording. So we have a lot more to go on.
Correct. But I would note that the invoices that we have yet to talk about, that the lower court never even gave any consideration to, those don't take place until September of 2021. So these conversations, the bulk of these conversations that took place in January 2021, March, May 2021, this entire period, Mr. Lajudis, the plaintiff, was never getting any compensation during this period of time. The parties continuously discussed the terms of their agreement, some of which was captured on the recordings. But of course, there were a lot more conversations between the parties, which should be explored during discovery. Again, this is a pre-answer motion to dismiss.
There's a lot of conversations that weren't surreptitiously recorded. What you're saying?
Yes,
I recorded a lot of them, but not all of them.
Correct, and I did state in my reply brief, I do take issue with the surreptitiously part that Mr. Collins did raise in his brief. I don't, that speaks to character, credibility, not to. So yes, they were recorded without her consent, without her knowledge, but at the same time, had they not been, we wouldn't be sitting here today. You would be completely without any kind of.
Your client could have demanded a written contract, and then we wouldn't.
He could have.
Counselors, I fundamentally fundamentally, I don't read your brief as objecting to or otherwise saying that the court should not have considered these phone conversations. You put them in.
Correct.
So, and you're not objecting to the court converting this to summary judgment without notice. You're saying, even considering it, we still have enough to survive this motion.
Correct. And I don't believe, looking back at the court's decision, that they converted this to a.
Nor did you object if he had done so.
No.
Because this does have summary judgment tree elements feeling to it.
It does, to an extent, but again, there's absolutely no evidence presented by the defendant in support of their motion, whether it be a motion to dismiss or a motion for summary judgment.
Right. Yeah, we got your argument as laid out in the briefs. We'll take another close look at that.
Thank you.
Thank you, Mr. Collins.
Good afternoon, Your Honors. Please the court, John Collins on behalf of Christie Johnson and Christie's Cleaning, the defendants in this action. The Supreme Court properly determined the recorded conversations that plaintiff submitted in opposition to defendant's motion to dismiss refute as a matter of law plaintiff's claim that in January 2021, the parties entered into the so-called 50-50 split oral contract. I think particularly telling and dispositive here is the final recorded call that was submitted from May 19, 2021, in which, and it's, we don't have a transcript of this, but I've listened to this multiple times, take notes as to what time things were said. And at, 4 minutes, 57 seconds into that conversation, Mr. LaJudas acknowledged that he and Christie Johnson had not yet reached an agreement. Shortly after, he offered her 4 options: mutually terminate the relationship, which he would, quote, be okay with. Ms. Johnson could pay him to find employees, but he wouldn't insist in the business's operation. Third, Ms. Johnson could pay him on an hourly basis. Or fourth, Mr. LaJudas suggested he and Ms. Johnson could do the deal they had, quote, talked about.
Which is 50-50.
Which is, as of January 1, we'd act like we were partners.
Right. So is there a distinction to be made between, let's say it's undisputed that they agreed to a 50-50 split of net proceeds, net profits. Is that doesn't necessarily follow that she agreed to give him half equity in her business? Is that correct?
Certainly not. No, I mean, it's our position as set forth in Ms. Johnson's affidavit that there was never any agreement that there would be a lifelong and essentially in perpetuity agreement whereby even if he wasn't involved in consulting work or assisting with the business plans and operation, that he would indefinitely get paid, 1/2 of the net proceeds or profits of the business, nor was there an agreement made that regardless of when the business was sold, and it's still extant, run by Ms. Johnson, who's present here watching this, that he, regardless of his lack of continued involvement, would get 1/2 of the net profits.
Mr. Collins, just real quick. There was clearly an agreement between the parties of some sort. You don't dispute that. Your client doesn't dispute that because the invoices here show that there was an agreement to pay the plaintiff something for something, right?
And he received many thousands of dollars, yes.
And it's probably also evidenced in the record that there was a 50-50 split of current income based on what I refer to as the true up. My words, not in invoices, but it's in the invoices that the defendant will give back this, will take that at the end of the year or the end of the quarter. So even the 50-50 split during the relationship seemed to be evidenced. Would you agree with that?
There was some evidence that, yes, he was getting, they were essentially splitting, the net proceeds or, profits of the business during that time.
And for my part, the last question I have is, but for these telephone conversations that were recorded, is it fair to say that reading the court's decision, it looks like the court, based its decision almost entirely on those. Is that fair, do you think?
I think it's fair, and I think it was proper for this reason. I was talking about that May 19th phone call, And at, one point, Mr. LaJudas acknowledged that no decision had been made as of the, true nature of the parties' arrangement, and stated that, quote, as of the present time, he was not guaranteed anything. And then subsequently, Ms. Johnson said she couldn't make a final decision until conferring with her husband. And I think that conversation, along with some earlier ones, just belies as a matter of law, the allegation that there was definitely the so-called 50-50 split arrangement made in January of 2021. Therefore, contrary to plaintiff's argument, there was no meeting of the minds as to that 50-50 split. And in fact, there wasn't even an agreement to agree, which in any event would be insufficient to support the establishment of an enforceable oral contract. And I know the court raised some question as to whether, this is really, treated like a summary judgment motion. I submit that it wasn't, but it was properly treated as a 3211A7 motion because there was evidence submitted by the defendant, or rather by the plaintiff himself, in the form of these recordings that flatly contradicts the existence of the 50-50 split agreement.
The trial court said he may have stated a cause of action, but he doesn't have one.
Correct. As established by these recordings, which I submit are the equivalent of documentary evidence.
All right. Thank you, Mr. Collins.
Thank you.